Hello, this is Bradley Pierce reporting from right outside the United States Supreme Court. Just to introduce myself, I'm the executive director of the Foundation to Abolish Abortion and Abolish Abortion Texas. Thank you very much for joining the live stream today. We will be streaming here today from outside the U.S. Supreme Court because the Supreme Court is hearing a very important case I'm going to tell you about in just a moment. We're here, as you can see behind me. There's lots of people here from both the pro-life side and from the pro-abortion side. They're both speaking behind me, so I hope you can hear me well. But we're going to be live streaming here today. I want to tell you a little bit about what the case is that the court's going to be hearing today. I want to tell you about the significance of it. And then at 10 a.m. Eastern, 9 a.m. Central, we're going to be switching to a live feed of the oral arguments from inside the Supreme Court. So you'll get to listen live to what the Supreme Court arguments are hearing. You'll get to hear live from the attorneys, live from the justices, and their questions for the attorneys as they discuss this matter back and forth. So what are we hearing today? We're hearing the Supreme Court is hearing the Dobbs case. It's Dobbs versus Jackson Women's Health Organization's case out of Mississippi. And Dobbs is the government from Mississippi. And so what the Supreme Court is going to be discussing today is whether all pre-viability prohibitions on elective abortions are unconstitutional. That's what they granted cert on. That is, they granted an appeal on that question to decide that question, whether or not all pre-viability prohibitions on elective abortions are unconstitutional or not. They're going to be talking about Roe versus Wade. They're going to be talking about Planned Parenthood versus Casey from 1992. They're going to be talking about woman's so-called right to choose, compared with a child's right, and the right of the state governments to regulate homicide, to regulate and prohibit homicide. So that's what they're going to be talking about today. This is really a historic case that directly challenges Roe versus Wade. There's been a number of cases that have come up before the U.S. Supreme Court over the years. Not all of them directly challenge Roe versus Wade, but this one does. I'm going to be telling you a little bit in a little while about a brief that we filed, the Foundation to Abolish Abortion and Abolish Abortion Texas, and 19 other organizations and 20 state legislators, a brief that we filed with the court. I'm going to be telling you about it a little bit. I may not have time before the Supreme Court's oral arguments, but I'm going to tell you more about it afterwards. But right now, I want to encourage you right now to go to the link in the description or the link in the post here with this if you're on Facebook, and sign the brief and show your support. Because the Supreme Court, we have a link in our brief so the Supreme Court can see your name. If you go and add your name to the brief, Supreme Court can go to that link and see your name on the brief. It won't have your identifying information, zip code, or email. That's just for us. That's not for the Supreme Court. But go now. I encourage you, abolishabortiontx.org. Sign the brief and show your support for abolishing abortion. So the court is hearing the Dobbs versus Jackson Women's Health case. They're having oral arguments today. They're not going to be actually deciding the outcome of the case, but they're having oral arguments about it. So what is this case about? It's about a 2018 law that Mississippi passed restricting abortions after 15 weeks. After 15 weeks post-fertilization is how it is. Dobbs is simply the state health officer of the Mississippi State Department of Health, and Jackson Women's Health Organization is an abortion provider, an abortion clinic in Jackson, Mississippi, and in fact is the only abortion clinic in the state of Mississippi, or at least that does surgical abortions. Again, like I said, the case is really whether all pre-viability prohibitions on elective abortion are unconstitutional, and whether states can ban abortion before viability, that is, before when a baby can survive outside the womb. The case is directly challenging Roe versus Wade and Planned Parenthood versus Casey. So why is it doing that? Why does it challenge Planned Parenthood versus Casey and Roe versus Wade? In Planned Parenthood versus Casey, a lot of people have heard about Roe versus Wade, but maybe you're not as familiar with Planned Parenthood versus Casey. Well, that was a 1992 case from the Supreme Court that considered the issue of Roe versus Wade and ultimately upheld it and doubled down on it in spite of the fact that the court was made up of 8 Republican appointees, and the only Democrat appointee on the court was pro-life. He actually opposed Roe versus Wade and voted against it. But in spite of that, the Planned Parenthood versus Casey upheld the core holdings of Roe versus Wade. So that's why it's also under consideration today. And they're asking whether under the Constitution a state may prohibit elective abortions before viability. Mississippi is arguing, yes, a state may, because nothing in the constitutional text, structure, history, or tradition supports the right to abortion. And we certainly agree with that. The arguments are going to be happening here, like I said, in about 19 minutes at 10 a.m. Eastern. And the arguments will last for around 70 minutes. They may go a little over if the justices want to go over their time. So what the format is going to look like is that each lawyer for each side, and I'll be telling you about those attorneys in just a moment, they will each have a couple of minutes to give their side of the argument completely uninterrupted. And then for the rest of their time, it's going to be kind of a free-for-all where the justices can interrupt, ask questions, and challenge what those attorneys are arguing. At the end of that part of the attorney's time, then the justices will have an opportunity one by one so that all of them get an opportunity to go through each of them and ask their questions of the attorney for their attorneys to answer those questions. So that'll happen for the petitioners, which is Dobbs, that is Mississippi, and then it'll happen for the Jackson Women's Health and their attorneys representing the pro-abortion side. And then the Biden administration has decided that they wanted to weigh in on this case. And so the Solicitor General of the United States of America will also be arguing, and we'll get a portion of the pro-abortion side of the argument. Let me just tell you a little bit about the justices today. Many people are aware of the Supreme Court. Maybe you've heard of it, 1 or 2 justices. Maybe you're familiar with all of them. But for those of you who are not, let me just tell you about who we're talking about today and who's going to be hearing these oral arguments today. So the Chief Justice of the United States Supreme Court is Chief Justice John Roberts. He was appointed by George W. Bush in 2005. He's been on the court quite a while. But there are actually 2 more senior, as far as their seniority on the court, their length of time on service on the court, than him. The one with the most seniority of all is Justice Clarence Thomas. Justice Clarence Thomas was appointed by George H.W. Bush, President George H.W. Bush in 1991. And Justice Thomas, as many of you know, has been a very consistent voice in support of overruling and overturning Roe versus Wade and Planned Parenthood versus Casey. In fact, he's been the only one who's been public in his views that Roe versus Wade should be overturned, that Planned Parenthood versus Casey should be overturned, and that this issue should be returned to the states, and that Roe versus Wade is unconstitutional. He's the only one of the justices who has been public in voicing that. The next in order seniority is Justice Stephen Breyer. He's appointed by President Bill Clinton in 1994. There's also Justice Samuel Alito, who was appointed by President George W. Bush. Then there are also 2 justices appointed by President Barack Obama, Justice Sonia Sotomayor and Justice Elena Kagan. Following them, President Trump was able to appoint 3 justices to the United States Supreme Court, which no president has done since President Ronald Reagan, I believe. If I'm wrong, I'm sure someone will correct me in the comments. But Justice Neil Gorsuch was his first appointee, followed by Justice Brett Kavanaugh, and finally the most recently appointed justice to the U.S. Supreme Court, Justice Amy Coney Barrett. So at this moment, the makeup of the court is 6 Republican appointees and 3 Democrat appointees, which makes it sound like, wow, this case should be a slam dunk. We should be able to end abortion, overturn Roe versus Wade, return it to the states at the very least with this case. What a lot of people don't know is that this is the exact makeup of the court as it was in 1973 when the Supreme Court gave us Roe versus Wade in the first place. In 1973, the makeup of the court was 6 Republican appointees and 3 Democrat appointees. And like I said, in 1992, the makeup of the court was 8 Republican appointees and the only Democrat appointee was pro-life and against Roe versus Wade. So I hope that we've learned. I hope that we're learning over the years that these cases are important. What the justices decide are important, but don't hold your breath that they're going to be overturning Roe versus Wade. That's what we pray for. That's what they should do. They should repent of what this institution has done and what it has continued to do, and they should overturn Roe versus Wade. That's what we pray they should do. That would be the right thing to do. So that's what we pray for, but we're certainly not holding our breath. And if you've been following Foundation to Abolish Abortion or Abolish Abortion Texas for very long, you know that our position is that, yes, the Supreme Court should overturn Roe versus Wade, but the state should stop waiting for them to do so because Roe versus Wade is unconstitutional. That's the whole reason they should overturn it. And if it's unconstitutional, then why are the states following it now? Why are they following it now? If it's unconstitutional, then it's not binding on the states, and we should stop following it. So that's what we call at the Abolish Abortion Texas, ignore Roe. So that's what we, no matter, regardless of what the Supreme Court ends up saying in this case, that's what we will continue to say through the Foundation to Abolish Abortion and Abolish Abortion Texas. So there's going to be 3 people that are going to be arguing in front of the court today that we're going to be hearing from, in addition to the justices that I've just introduced to you. We're going to be hearing from the Solicitor General of Mississippi. His name is Scott Stewart, and he will have 35 minutes to represent the state of Mississippi. Now, he may choose to divide him, so that way he gets the last word. Then there will also be Jackson Women's Health Organization, Julie Rickelman, litigation director of the Center for Reproductive Rights. We'll have approximately 20 minutes, followed by the U.S. Solicitor General, Elizabeth Prelogar. We'll also have 15 minutes to argue in support of Jackson Women's Health Organization. So that's the people that we're going to be hearing from today, from the Solicitor General of Mississippi, from the Center for Reproductive Rights, their attorney representing Jackson Women's Health, and then we're going to be hearing from the United States Solicitor General from the Biden administration, Elizabeth Prelogar. So we're going to be giving you that feed here in about 13 minutes, turning into the Supreme Court. If you haven't already, I want to remind you, go to this link in the description. Go to the link here in the post, or if you can't, you can see it right there on the screen, abolishabortiontx.org. Sign the petition, show the court that you support not just overturning Roe versus Wade, but abolishing abortion. That's the right thing to do their duty under the Constitution, and more importantly, their duty before God. So we're going to be, as you're hearing right behind me, there's lots of people outside the U.S. Supreme Court having rallies right now. We have both the pro-life side, we have the pro-abortion side. There's some abolitionists out here as well, several abolitionist organizations we're excited about, and hopefully we'll be able to get some of those folks over later on after the live feed of oral arguments and introduce you to them and hear from them and why they're here. Many of them signed on to this brief and hear why they did that, what they support, signed on to, I should say, our brief before the U.S. Supreme Court. So after oral arguments, a lot of people say, well, what happens after today? What happens after December 1st? Well, nothing's going to be decided today. Today is simply the day that the court hears the arguments. All the arguments have already been submitted in written form, both by the parties and by what are called friends of the court, or the amicus curiae, a Latin phrase that means friends of the court. So we're one of those, the Foundation to Abolish Abortion and Abolish Abortion Texas, along with 19 other organizations and 20 state legislators from across the country. So that's already been submitted in writing, but we have oral arguments, so the justices have an opportunity to directly engage with the attorneys for the parties in the case, so that way they can try to narrow in the issues and focus on what are the most important issues and get some of their questions answered to help them narrow in on the issues. So that's why we're here today, to hear that. So it's going to give us an opportunity to hear directly from the parties, Mississippi, Jackson Women's Health, and the Biden administration, arguing for their positions on this case. So we're going to be able to hear them focus in on what their arguments really are, how strong they are, what are they based in, what's the foundation of those arguments. Are they ungodly arguments? Are they pragmatic, or are they principled? We're going to be hearing that. And we're also going to be hearing from the justices themselves as they ask their questions. And it's going to give us maybe a little bit of insight into where they're leaning, what they're thinking. So we're going to be doing that. We're going to be hearing that from the live feed here in just about 10 minutes. Whatever happens ultimately in this case, the result is going to be big. Even if the Supreme Court doesn't do anything big, the outcome is going to be very large. The Supreme Court could certainly overturn Roe versus Wade. That's one option, and they could return the issue to the state. They could even go further than that, which is what we've argued for in our brief, and not just overturn Roe versus Wade, but even hold that a preborn child, a fetus, is a person for constitutional purposes under the 14th Amendment, and therefore is entitled to equal protection of the laws. The Supreme Court could do that. That's what we're arguing for, as we believe they constantly should do. But that's not a lot of people really expect that. But they could also hold that Roe versus Wade is unconstitutional and overturn it and return it to the states. So that's one of the things that they could do. They could also uphold Roe versus Wade and Planned Parenthood versus Casey. That's certainly an option. Hopefully they don't do that, but that's certainly an option. So that's something that we're going to be listening for, just to kind of give us a hint as to what they could do. But there's a lot that could happen between now and then. Asking, well, when will we know? When will we know what the outcome of this case is going to be? When will we know what the court's opinion is? Well, that could come at any point between now and July. Potentially could even come afterwards in the court's next term, but very, very unlikely. It's very likely to come out this term. Supreme Court will issue their ruling, their opinion in this case, and that will then come out likely in June is when a lot of the more controversial cases are announced in June. Could it happen before then? It certainly could. But that's kind of, the general wisdom is that it's expected in June. Unfortunately, they won't really give us a whole lot of notice, if any, about when they're going to be announcing that. So between now and then, we just have to wait and see, and most importantly, pray. And like we've said at the Abolish Abortion Texas and the Foundation to Abolish Abortion, regardless of what they do, we need to keep working in our state legislators to ignore Roe and provide equal protection from the moment of fertilization. So that's what we argue for, regardless of what the Supreme Court does. Now, that said, we do hope and we pray, and we've even submitted a petitioning the Supreme Court. I'm sorry, a brief asking the Supreme Court to do their duty before God and under the Constitution and provide equal protection and abolish abortion by overturning Roe versus Wade. So if Roe versus Wade and Planned Parenthood versus Casey are overturned, what would that do if the Supreme Court were to overturn those two decisions? Well, that would return it to the states, effectively. So that way it would then be up to the states how they choose to ban, prohibit, regulate, restrict abortion. So that would be up to each state. The Guttmacher Institute, basically an arm of Planned Parenthood, their research arm of that organization, they predict that around 26 states would certainly or likely ban abortion, if that's the case. A number of those states would happen automatically, either because of pre-Roe laws that are still in the books in those states, or because of trigger bills or trigger laws that have been passed in those states that would immediately make abortion illegal in those states. It wouldn't necessarily make it equal protection. I'm not aware of any state where it would actually be equal protection. So there would still be a lot of work to be done, even if the Supreme Court were to overturn Roe versus Wade. Take down the Mississippi law, then that's going to be pretty devastating to the pro-life movement, which has for now 49 years kind of pinned its hope on the Supreme Court here and what they decide. And again, that's a big part of the problem, like we've been talking about since we've started these organizations, that we shouldn't be pinning our hopes here, right? They should do the right thing. We should work for the Supreme Court to do the right thing. But that should not be where we put our faith and our hope. We don't put our trust in princes. We don't put our faith in the Supreme Court, especially because Roe versus Wade is unconstitutional. It's not binding on the states. And more importantly, it's evil. And so we believe that our governors, our legislators, our other civil officials, they have a duty to disregard Roe versus Wade It's not the law of the land because it's unconstitutional, and they should be returning the issues to the state. Something else that the Supreme Court could do is they could find a way to try to make as many people happy, or at least satisfied, or at least not as angry as possible. And so that they could actually uphold the Mississippi 15-week ban and uphold it, which would make abortion illegal after 15 weeks, while at the same time upholding Roe versus Wade and Planned Parenthood versus Casey. Finding a way to say that a 15-week ban does not create an undue burden to a pre-viability abortion. I don't know exactly how they would do that, but the Supreme Court has been pretty creative ever since Roe versus Wade on this issue about finding ways to skirt or directly defy the U.S. Constitution and, of course, God's law. So we're calling them to stop doing that, do their duty, follow God, follow the Constitution, overturn Roe, and provide equal protection. So that's what our brief does. And so we, our hope is that whatever happens in this case, that the pro-life movement will stop pinning its hopes just right here, just on the Supreme Court, right? This is not where we place our hope. Part of me thought about coming out here this morning and saying, be your God, right? Because that's a lot of the ways that a lot of us treat the U.S. Supreme Court, is that no matter how wrong they are, no matter how unconstitutional they are, no matter how evil their decisions are that they make, nevertheless, we still have to follow them no matter what. Well, that's how you treat God, right? We're supposed to follow God and obey him unconditionally. But that's not how we're supposed to be treating a human institution. Yes, we should submit to it. Yes, it's a governing authority. Yes, we should submit to it within its governing authority. But when it violates that, when it violates that jurisdiction, and especially when it commands governors and it commands legislators and it commands civil magistrates to do what God forbids, which is to show partiality and judgment, and to forbid what God commands, which is to do justice and to do justice for the fatherless, well, that's where we draw the line. Whenever the Supreme Court is commanding us to do what God forbids, or forbidding us from doing what God commands, or commanding our magistrates from doing, forbidding them from doing what God commands, or commanding them to do what God forbids, that's where we draw the line, and we have to say no. We have to say no to that. So, yes, we're here because this is important, and what Supreme Court does in this case is very, very important, and it matters a lot. But it's not the only thing we should be working on. It's not the only thing we should be fighting for. This is not where we should be putting our hope and our trust. We should be putting that in God. And so we're going to be hearing, we're almost there, just a couple minutes away from hearing the oral arguments in this case. So if you agree with, if you're just now finding out about abolition and abolishing abortion, but you agree with what I just said, then I encourage you, go to our brief at abolishabortiontx.org. Sign your name. Add your name to the brief. And if while you're there, you want to support the work that we're doing, support us being out here, support us fighting to abolish abortion, then after you sign the brief, there's an opportunity for you to donate. We'd love your support, but we understand not everybody can do that. So we're going to be tuning in very, very shortly, 2 oral arguments. So please go ahead and go sign that brief at abolishabortiontx.org/sign the brief. All right. I'm getting word that we're about to go to the oral arguments live feed. And then afterwards, I'm going to be coming back and giving you my analysis of what we just heard so that we can just kind of thinking through the arguments that the sides made, what we heard from the justices, and analyzing that. As an attorney, I'm an attorney. I'm a member of the Supreme Court Bar, and I filed our brief in that case. So I'm going to be telling you about what you just heard once we hear that from the U.S. Supreme Court. So we're going to be tuning there in just a moment. But right now, go ahead and go add your name to the brief, abolishabortiontx.org/sign the brief. The link is in the post, or the link is in the description, wherever you're at. Are we almost to are we ready to go to the feed? All right, let's go over to the feed.
The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
We will hear argument this morning in Case 19-1392, Dobbs versus Jackson Women's Health Organization. General Stewart.
Mr. Chief Justice, and may it please the court. Roe versus Wade and Planned Parenthood versus Casey haunt our country. They have no basis in the Constitution. They have no home in our history or traditions. They've damaged the democratic process. They've poisoned the law. They've choked off compromise. For 50 years, they've kept this court at the center of a political battle that it can never resolve. And 50 years on, they stand alone. Nowhere else does this court recognize a right to end a human life. Consider this case. The Mississippi law here prohibits abortions after 15 weeks. The law includes robust exceptions for a woman's life and health. It leaves months to obtain an abortion. Yet the courts below struck the law down. It didn't matter that the law applies when an unborn child is undeniably human, when risks to women surge, and when the common abortion procedure is brutal. The lower courts held that because the law prohibits abortions before viability, it is unconstitutional no matter what. Roe and Casey's core holding, according to those courts, is that the people can protect an unborn girl's life when she just barely can survive outside the womb, but not any earlier when she needs a little more help. That is the world under Roe and Casey. That is not the world the Constitution promises. The Constitution places its trust in the people. On hard issue after hard issue, the people make this country work. Abortion is a hard issue. It demands the best from all of us, not a judgment by just a few of us. When an issue affects everyone, and when the Constitution does not take sides on it, it belongs to the people. Roe and Casey have failed, but the people, if given the chance, will succeed. This court should overrule Roe and Casey and uphold the state's law. I welcome the court's questions.
General Stewart, you focus on the right to abortion, but our jurisprudence seems to focus on, in Casey, autonomy, in Roe, privacy. Does it make a difference that we focus on privacy or autonomy, or more specifically on abortion?
I think whichever one of those you're focusing on, Your Honor, particularly if you're focusing on the right to abortion, each of those starts to become a step removed for what's provided in the Constitution. Yes, the Constitution does provide, protect certain aspects of privacy, of autonomy, and the like. But as this court said in Glucksberg, going directly from general concepts of autonomy, of privacy, of bodily integrity, to a right is not how this court traditionally does due process analysis. So I think it just confirms whichever one of those you look at, Your Honor, a right to abortion is not grounded in the text, and it's grounded on abstract concepts that this court has rejected in other contexts as supplying a substantive right.
You say that this is the only constitutional right that involves the taking of a life. What difference does that make in your analysis?
Sure, Your Honor. I think it makes a number of differences. One, I mentioned two in particular. One is it really does mark out the unbelievably profound ramifications of this area, which in many other areas, assisted suicide, a whole host of important areas that are important to dignity, autonomy, freedom, and important to matters of conscience. It marks it out as one of the unique areas where this court has taken that important issue to the people. And it's something that implicates life. And it just, I think, marks off, Justice Thomas, how problematic and unusual and how much of a break the court's abortion jurisprudence is from those other cases.
If we don't overrule Casey or Roe, do you have a standard that you propose other than the viability standard?
It would be, Your Honor, a clarified version of the undue burden standard. I would emphasize, I think, as Your Honor is alluding to, that no standard other than the rational basis review that applies to all laws will promote an administrable, workable, practicable, consistent jurisprudence that puts matters back with the people. I think anything heightened here is going to be problematic, but I would say if the court were not inclined to overrule Casey, the choice would be undue burden standard, untethered from any bright line viability rule.
Thank you. Well, I'd like to go to a different topic, back to Casey.
Yes,
I assume you've read Casey pretty thoroughly.
Yes, Your Honor.
And there are two parts. One is they reaffirm Roe. Put that to the side. The second is an opinion for the court, not for three people, but for the court. And that second part is about what stare decisis principles should be used to overrule a case like Roe. And they say Roe's special. What's special about it? They say it's rare. They call it a watershed. Why? Because the country is divided, because feelings run high, and yet the country, for better or for worse, decided to resolve their differences by this court laying down a constitutional principle, in this case, women's choice. That's what makes it rare. That's not what I'm asking you about. I want your reaction to what they said follows from that. What the court said follows from that is that it should be more unwilling to overrule a prior case. Far more unwilling we should be, whether that case is right or wrong, than the ordinary case. And why? Well, they have a lot of words there, but I'll give you about 10 or 20. There will be inevitable efforts to overturn it. Of course there will. Feelings run high. And it is particularly important to show what we do in overturning a case is grounded in principle and not social pressure, not political pressure. Only, quote, the most convincing justification can show that a later decision overruling, if that's what we did, was anything but a surrender to political pressures or new members. And that is an unjustified repudiation of principles on which the court stakes its authority. And then there are two sentences I'd like to read, because they say they really mean this, the court, not just three. To overrule under fire in the absence of the most compelling reason to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question. And the last sentence, after they quote Potter Stewart on the same point, they say overruling unnecessarily and under pressure would lead to condemnation, the court's loss of confidence in the judiciary, the ability of the court to exercise the judicial power and to function as the Supreme Court of a nation dedicated to the rule of law. Now, that's the opinion of the court. All right? And it's about stare decisis and how we approach it. And I hope everybody reads this. It's at 505 U.S. 854 to 869. All right. What do you say to that?
Sure, Justice Breyer. I would say a couple things. I would say we have very closely gone through the factors that the Casey court itself went through in stare decisis. More than half of our brief is devoted to stare decisis. We now have 30 years in the wake of Casey to see what Casey has done and what it hasn't done.
Well, it's called some bad things in the eyes of some people and some good things in the eyes of some people.
Your Honor.
All right, go ahead.
I'm sorry, Your Honor. What I'd emphasize, Your Honor, is that to the extent that I would not say it was the people that called this court to end the controversy. The people, many people vocally really just wanted to have the matter returned to them so that they could decide it locally, deal with it the way they thought best, and at least have a fighting chance to have their view prevail, which was not given to them under Roe and then as a result under Casey. And I'd also emphasize, Your Honor, that on stare decisis, just as I said, the last 30 years, workability, developments in the law, factual developments that states can't account for, the workability, the undue burden standard alone, many problems. On all the metrics that Casey was describing, or the vast bulk of them, Casey fails. And I'd also emphasize this as well, Justice Breyer, that Casey was not a great example of simply letting precedent stand. It recast Roe's reasoning. It overruled two of the court's most important abortion decisions. It jettisoned the trimester framework of Roe itself and adopted a new standard unknown to other parts of the law. Those are not the hallmarks of precedent, and they failed under this court's stare decisis.
Okay, can I take it that your answer is, yes, you accept the way, the special rule, the rule for the rare watershed, the stare decisis principles for deciding whether to overturn such a case as Roe. You accept that, and you think it's met.
I would say yes, in part, Justice Breyer. And here's what I'd emphasize is that I do think, particularly when Casey looked outward and looked to what it saw as pressure, there were pressure on all sides. As Your Honor noted, this is a hot, difficult issue for everyone. That's why it belongs to the people. And I think the conclusion the court drew from that it couldn't provide a good enough example, that it would look unprincipled, those conclusions were, with respect, Justice Breyer, mistaken. And the last 30 years has not seen any calming of that. It's been very different than some of the court's other controversial decisions that have seen much more calm.
What hasn't been at issue in the last 30 years is the line that Casey drew of viability. There has been some difference of opinion with respect to undue burden, but the right of a woman to choose, the right to control her own body, has been clearly set for since Casey and never challenged. You want us to reject that line of viability and adopt something different. 15 justices over 50 years have, or I should say 30 since Casey, have reaffirmed that basic viability line. 4 have said no, 2 of them members of this court, but 15 justices have said yes, of varying political backgrounds. Now, the sponsors of this bill, the House bill in Mississippi, said we're doing it because we have new justices. The newest ban that Mississippi has put in place, the 6-week ban, the Senate sponsor said, we're doing it because we have new justices on the Supreme Court. Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts? I don't see how it is possible. It's what Casey talked about when it talked about watershed decisions. Some of them, Brown versus Board of Education, it mentioned, and this one, have such an entrenched set of expectations in our society that this is what the court decided, this is what we will follow, that we won't be able to survive if people believe that everything, including New York versus Sullivan, I could name any other set of rights, including the Second Amendment, by the way. There are many political people who believe the court erred in seeing this as a personal right as opposed to a militia right. If people actually believe that it's all political, how will we survive? How will the court survive?
Justice Sotomayor, I think the concern about appearing political makes it absolutely imperative that the court reach a decision well-grounded in the Constitution, in text, structure, history, and tradition, and that carefully goes through the stare decisis factors we've laid out.
That.
No, it didn't.
Casey went through every one of them. You think it did it wrong. That's your belief. But Casey did that.
Well,
And you haven't added
Your Honor.
much to the discussion in your papers as to the errors that Casey made, other than I disagree with Casey.
Justice Sotomayor, maybe I can highlight two. Casey gave one paragraph to the workability of Roe. It then adopted the undue burden standard, which is perhaps the most unworkable standard in American law. It gave about 3 paragraphs, if memory serves, to reliance, which doesn't account for the last 30 years and the changes that have occurred since Casey. It gave a brief factual view to things that have changed since Roe. Those, of course, are not going to take account of the last 30 years of advancements in medicine, science, all of those things.
What are the advancements in medicine?
I think it's an advancement in knowledge and concern about such things as fetal pain, what we know the child is doing and looks like and is fully human from a very early...
In regular cases, courts decide whether science fits the Daubert standard. Obviously, under the Daubert standard, the minority of people, a gross minority of doctors, who believe fetal pain exists before 24, 25 weeks. It's a huge minority, and one not well founded in science at all. So I don't see how that really adds anything to the discussion. That a small fringe of doctors believe that pain could be experienced before a cortex is formed doesn't mean that there's been that much of a difference since Casey.
We pointed out as an example, Your Honor, of where Roe and Casey improperly preclude states from taking account for these things, and they should be able to be concerned about a fact of an unborn life being poked and then recoiling in the way one of us would recoil.
General, I know what it said about viability in Roe, but was viability an issue in the case? I know it wasn't briefed or argued.
It was not an issue certainly the way it is an issue here, Your Honor. I think it was, to the extent that the court had to reaffirm Roe. The way to read that as something other than dicta would be to understand.
I'm sorry, I don't know what that said. Was it an issue in Roe?
Oh, in Roe?
Yeah.
I'm sorry, Your Honor. My understanding is no. I mean, the law there was didn't have a viability tag. That was inserted by.
In fact, if I remember correctly, and it's an unfortunate source, but it's there. In his papers, Justice Blackmun said that the viability line was dicta, and presumably he had some insight on the question.
I think, and I'd add, Your Honor, Justice Blackmun, and I think as well his papers pointed out the arbitrary nature of it and the line drawing problems in there too.
And then in Casey said that was the core principle or the central principle in Roe, viability. It said that after tossing out the trimester formula, which many people thought was the core principle. But was viability at issue in Casey?
I don't think it was squarely at issue, Your Honor. Again, it's a little hard not to take the court at its word when it emphasized that viability, the viability is the central part of Roe's holding, and saying that it is reaffirming that. So we kind of take that as it stands, but the court has not. It did not face a law like this, certainly, Mr. Chief Justice.
May I finish my inquiry?
Of course, Justice Sotomayor.
Virtually every state defines a brain death as death. Yet the literature is filled with episodes of people who are completely and utterly brain dead, responding to stimuli. There's about 40% of dead people who, if you touch their feet, the foot will recoil. There are spontaneous acts by dead brain people. So I don't think that a response to by a fetus necessarily proves that there's a sensation of pain or that there's consciousness. So I go back to my question of what has changed in science to show that the viability line is not a real line, that a fetus cannot survive. And I think that's what both courts below said, that you had no experts say that there is any viability before 23 to 24 months.
And what I'd say is this, Justice Sotomayor, is that the fundamental problem with viability, it's not really something that rests on science so much. It's that viability is not tethered to anything in the Constitution, in history, or tradition. It's a quintessentially legislative line. A legislature could think that viability makes sense as a place to draw the line, but it's quite reasonable for a legislature to draw the line elsewhere.
There's so much that's not in the Constitution, including the fact that we have the last word. Marbury versus Madison. There is not anything in the Constitution that says that the Supreme Court, is the last word on what the Constitution means. It was totally novel at that time. And yet, what the court did was reason from the structure of the Constitution that that's what was intended. And here in Casey and in Roe, the court said there is inherent in our structure that there are certain personal decisions that belong to individuals and the states can't intrude on them. We've recognized them in terms of the religion parents will teach their children. We've recognized it in their ability to educate at home if they choose. They just have to educate them. We have recognized that sense of privacy in people's choices about whether to use contraception or not. We've recognized it in their right to choose who they're going to marry. I fear none of those things are written in the Constitution. They have all, like Marbury versus Madison, been discerned from the structure of the Constitution. Why do we now say that somehow Roe versus Roe and Casey are so unusual that they must be overturned?
Well, Justice Sotomayor, I would emphasize two things. When you're going beyond the Constitution, this court has looked closely to—
No, what I'm saying is they didn't go beyond the Constitution.
Your Honor, they did not deduce those from the structure of the Constitution. They pointed to the 14th Amendment and reasoned that privacy in Roe, autonomy and similar values in Casey led to a right to abortion. That's not how this court traditionally does things, including in the vast run of cases that Your Honor ran through. The court looks to history and tradition, and here those decisively reject the proposition that states cannot legislate comprehensively on abortion before, after viability, and all throughout. So it's history and tradition, Your Honor. And I would also add, Your Honor, that those decisions, a great many of them draw, not just draw from text, history, and tradition, but they draw often clear lines, very workable, have not led to the many negative stare decisis factors that we identify here.
General, Go ahead, Dr. Barrett. Would a decision in your favor call any of the cases, that Justice Sotomayor is identifying into question?
No, Your Honor. I think for a couple reasons. First of all, I think the vast run of those cases, and some mentioned from time to time, I think Griswold, Lawrence, Obergefell, these are cases that draw clear rules. You can't ban contraception, can't ban intimate romantic relationships between consenting adults, can't ban marriage of people of the same sex. Clear rules that have engendered strong reliance interests and that have not produced negative consequences or all the many other negative stare decisis considerations we pointed out, Your Honor. Also, I'd add, none of them involve the purposeful termination of a human life. So those two features, stare decisis and termination of a human life, Your Honor, puts all of those safely out of reach if the court overrules here.
Okay, so I'm sorry to interrupt again, but we really might be making progress. I mean, in the part that I read, of Casey,
yes, Your Honor.
I think they think go back 150 years, maybe now we could go back 200. They think there have only been two cases, which were what they call the watershed, and where these special tough overruling rules apply. You want this to be the third? Or do you think there were more? And if so, what were they?
Well, Your Honor, I think there's quite a bit of difference. I think the question is never, is it bad to overrule, period? Surely Starr.
I'm asking you to think in their terms. There were two they mentioned, say. And they don't want they don't want Roe to be the third. And now, in your opinion, you just answered Justice Barrett, hey, all these are not rising to that level. Okay. Right. Are there any that do rise to the level, in your opinion?
I think, and I'm not sure that I necessarily agree with the watershed characterization, Your Honor. What I'd say, though, I can't think of another that kind of hits the radar, but I'd emphasize that the problem here is we're dealing with a right that doesn't have a basis in constitutional text, and again, very much in conflict with those values, Justice Breyer.
I'm not sure how your answer makes any sense. All of those other cases, Griswold, Lawrence, Obergefell, they all relied on substantive due process. You're saying there's no substantive due process in the Constitution, so they're just as wrong according to your theater.
No, Your Honor, we're quite comfortable with Washington versus Glucksberg and how it analyzes substantive due process, and it looks to text history. It looks to history and tradition to discipline the inquiry and make sure.
I mean, in Obergefell, there was no history of same-sex marriage.
And I think the court pointed out, look, when we were facing Loving versus Virginia.
I'm not trying to argue that we should overturn those cases. I just think you're dissimilating when you say that any ruling here wouldn't have an effect on those.
Respectfully, that's.
Do you think that no state is going to think otherwise? That no people in the population aren't going to challenge those cases in court?
I mean, Your Honor, we'll always have a diversity of views, but I think that's
the point.
I think that's one of the benefits of our society.
Isn't that the point?
That there's a diversity of views and people can vigorously debate and make decisions
exactly, and that's what we're still doing, and that's what we're doing under undue burden, but we haven't been doing it on the viability line.
And neither has worked well. The viability line discounts and disregards state interests, and the undue burden standard has all of the problems that
How is your interest anything but a religious view? The issue of when life begins has been hotly debated by philosophers since the beginning of time. It's still debated in religions. So when you say this is the only right that takes away from the state the ability to protect a life, that's a religious view, isn't it? Because it assumes that a fetus is life at when? You're not drawing when do you suggest we begin that life?
Your Honor, aside from...
I'm putting it aside from religion.
I'll try to, I think there might be more than one question, and I'll do my very best, Justice Sotomayor. I think this court in Gonzalez pretty clearly recognized that before viability, we are talking with unborn life with a human organism. And I think the philosophical questions Your Honor mentioned, all those reasons that they're hard, they've been debated, they're important. Those are all reasons to return this to the people, because the people should get to debate these hard issues. And this court does not in that kind of a circumstance.
So when does the life of a woman and putting her at risk enter the calculus? Meaning, right now, forcing women who are poor, and that's 75% of the population, and much higher percentage of those women in Mississippi who elect abortions before viability, they are put at a tremendously greater risk of medical complications and ending their life, 14 times greater to give birth to a child full term than it is to have an abortion before viability. And now the state is saying to these women, we can choose not only to physically complicate your existence, put you at medical risk, make you poorer by the choice, because we believe what? That.
Sure, Your Honor. I think to answer, I think the question I think you led with, and then I think it expanded on, but is still on the same issue, is as to when does a woman's interest enter, as far as we're concerned, it's there the entire time. Our point is that all of the interests are there the entire time, and Roe and Casey improperly prevent states from taking account and weighing those interests however they think best. We're not saying—
General, are there secular philosophers and bioethicists who take the position that the rights of personhood begin at conception or at some point other than viability?
I believe so. I mean, I think there's a wide array, I mean, of people of kind of all different views and of no faith views who would reasonably have that view, Your Honor. It's not tied to a religious view, and I don't think, were it otherwise, this court's jurisprudence would, on this issue, would run right into some of its religious exercise jurisprudence.
General, Justice Breyer started with stare decisis, an important principle in any case. And here, for the reasons that Casey mentioned, especially so, to prevent people from thinking that this court is a political institution that will go back and forth depending on what part of the public yells loudest, and preventing people from thinking that the court will go back and forth depending on changes to the court's membership. And what strikes me about this case, and you come here very honestly, saying, you know, we want you to discard the entire setup, and then even if you don't do that, we want you to discard the viability line, which you've acknowledged again today. Casey says is the heart, the central principle of Roe. And so usually there has to be a justification, a strong justification in a case like this, beyond the fact that you think the case is wrong. And I guess what strikes me when I look at this case is that, you know, not much has changed since Roe and Casey, that people think it's right or wrong based on the things that they have always thought it was right and wrong for. So the rationale behind those cases has something to do with the autonomy and the freedom and the dignity of women to pursue their lives as they wish, to protect their bodily integrity, to make the decisions that are most fundamental to the course of their lives. And always in those cases, there was an understanding that there were important interests on the other side in protecting life or protecting the potential for life, whether people saw it one way or the other way, and that there was a difficult question here and a balance to be made. And I mean, it strikes me that some people think those decisions made the right balance and some people thought they made the wrong balance. But in the end, we are in the same exact place as we were then, except that we're not, because there's been 50 years of water under the bridge, 50 years of decisions saying that this is part of our law, that this is part of the fabric of women's existence in this country, and that places us in an entirely different situation than if you had come in 50 years ago and made the same arguments. So I guess I just wanted to hear you react to that.
Of course, Justice Kagan, thank you. I would emphasize a couple things, Your Honor. The fact that so much time has passed, let's say nothing had changed. That's not a point in Roe and Casey's favor. They have no basis in the Constitution. They adopt a right that purposefully leads to the termination of now millions of human lives. If nothing had changed, they'd be just as bad as they were 30 years ago, 50 years ago. And now we just have decades of damage, and we have a situation where nearly 30 years after Casey, the court unfortunately divides over what Casey, the lead case in the abortion area, even means. The lower courts are left not knowing what to do, as I think kind of a fundamental problem here is, I think, as Justice Gorsuch mentioned, emphasized in his opinion in June Medical, that the problem for lower court judges is the Constitution doesn't give them an answer to this. There's no neutral rule of law, so judges unfortunately have to look within themselves, and that's just never going to solve this issue. But if the matter's returned to the people can deal with it, they can work, they can compromise and reach different solutions. But if we don't do that, we're just going to have all this sort of damage. And at some point, it's appropriate for the court to say enough, as it has in some of the great overrulings in Brown and in other cases where it said, this is just enough. Justice Harlan had it right in dissent in Plessy when he recognized that all are equal, and similarly here, the state should be able to recognize, hey, there are real values on both sides here. We think that this one slightly outweighs, or we think that there's some balance to be drawn here. But if the court doesn't do that, Justice Kagan, it's just going to be continued damage, and the court will continue to plunge in this political issue. I apologize, Mr. Chief Justice, I've gone over.
No, that's all right. I have just a few little, well, not little, I hope, questions. And the first gets back to the issue of viability. In your petition for cert, your first question, and the only one on which we granted review, was whether all pre-viability prohibitions on elective abortions are unconstitutional. And then I think it's fair to say that when you got to the brief on the merits, you kind of shifted gears and talked a lot more about whether or not Roe and Casey should be overruled. And I wanted to give you a chance to explain that.
Sure, Your Honor. So a couple points. At the petition stage, we were, of course, we'd identified for the court 3 questions. We emphasized, as you do at the cert stage, hey, this is important. Only this court can resolve it. We emphasized, I believe it was 5 times, that the court was at the least going to need to reconsider, revisit, or reevaluate its precedents. And we asked the court to at least get rid of a viability line or any suggestion of a viability line. So we added, however, and we had to take account of the reality that this argument has not fared well in the lower courts. It's lost in every court of appeals. So, we raised the issue in addition, but once the court granted only the first question, we presented every argument as we, signaled we would present the full-blown constitutional merits argument with that fundamental question. So I'd emphasize that, Your Honor. It was kind of the shift. You go from cert stage to merit stage. The court granted one question. That question fairly includes what is the correct standard?
Well, it fairly includes the broader arguments you raised. I'm not suggesting that. But on the other hand, it presumably included the viability question as well, because that's what you talked about in that one sentence.
And we've addressed that as well, Your Honor. What I'd emphasize here is that the merits arguments of, the validity of Roe and Casey as an original matter, is there a viability rule based in the Constitution? Those are not that complicated or lengthy. The harder questions are, should the court overrule and take that momentous step? And that's why we devote a lot of space to that very important issue. We respect stare decisis and have walked through all those points. But again, focusing on the question presented and presenting our best arguments for that, that's what we've done, Mr. Chief Justice.
On stare decisis, I think the first issue you look at is whether or not the decision at issue was wrongly decided. I've actually never quite understood how you evaluate that. Is it wrongly decided based on the legal principles and doctrine when it was decided, or in retrospect? Because Roe, there are a lot of cases around the time of Roe, not of that magnitude, but the same type of analysis that went through exactly the sorts of things we today would say were erroneous. But do we look at it from today's? If we look at it from today's perspective, it's going to be a long list of cases that we're going to say were wrongly decided.
Well, I'd say, Mr. Chief Justice, that you can look both. Was it wrong at the time? Has it been unmasked as wrong by new understandings, new knowledge, and any developments? But I don't think, as I think my colloquy with Justice Barrett indicated, the court won't have to be looking at many other areas, because this is an area that has a uniquely problematic set of stare decisis considerations. A lot of other controversial areas, or once controversial areas, are quite settled, clear rules, and don't have those considerations against them. So really, by overruling Roe and Casey, the court won't have to go down that road, and a lot of those decisions are quite readily groundable in history, tradition, and the court's traditional factors, Your Honor.
Thank you. Justice Thomas? Justice Breyer? Justice Alito? Justice Sotomayor? Okay, Justice?
I just wanted to get your quick sense of how your intermediate positions would work. If basically the viability line was discarded and undue burden became the standard overall, a standard that, according to you, is an unclear one, what that would leave the court with going forward. You know, I'm just sort of thinking about the great variety of regulations that states could pass. So whether one is 15 weeks and one is 12 weeks and one is 9 weeks, or variation across a wide variety of other dimensions, what would that look like coming to the court? How do you think we would be able to deal with that, or how would you counsel us to deal with that if the court were to go down that road?
Well, I think this is not to push back against the end, and I will answer your question, Justice Kagan, but part of why we've counseled to overrule full scale is that that's the only way to get rid of a number of the problems that I think Your Honor is alluding to. And that's that when you have the undue burden standard, it's a very hard standard to apply. It's not objective. The court looks to the record in each case and what's going on. I mean, the court in Casey itself said under this record, this is not an undue burden. You couldn't say necessarily for certain that a certain number of weeks one place would be an undue burden, but would be okay another place. But again, that is the world we have under Casey. So if the court upholds this law under the undue burden standard, it would be carrying forward those features, which, and I hope I've answered your question, but I think that's one of the very strong reasons to just go all the way and overrule Roe and Casey, Your Honor. Anyway.
Justice Gorsuch? Justice Kavanaugh?
I want to be clear about what you're arguing and not arguing. Yes. And to be clear, you're not arguing that the court somehow has the authority to itself prohibit abortion, or that this court has the authority to order the states to prohibit abortion, as I understand it, correct?
Correct, Your Honor.
And as I understand it, you're arguing that the Constitution's silent and therefore neutral on the question of abortion. In other words, that the Constitution's neither pro-life nor pro-choice on the question of abortion, but leaves the issue for the people of the states or perhaps Congress to resolve in the democratic process. Is that accurate?
Right. We're saying it's left to the people, Your Honor.
And so for if you were to prevail, the states, majority of states, or states still could and presumably would continue to freely allow abortion. Many states, some states would be able to do that even if you prevail under your view. Is that correct?
That's consistent with our view, Your Honor. It's one that allows all interests to have full voice, and many of the abortions we see in certain states that I don't think anybody would think would be moving to change their laws in a more restrictive direction.
Thank you.
Thank you, Your Honor.
Justice Barrett?
General, I have a question that is a little bit of a follow-up to one that Justice Breyer was asking you. That's about stare decisis, and I think a lot of the colloquy you've had with all of us has been about the benefits of stare decisis, which I don't think anyone disputes. And of course, no one can dispute, because it's part of our stare decisis doctrine, that it's not an inexorable command and that there are some circumstances in which overruling is possible. You know, we have Plessy, Brett Brown, we have Bowers versus Hardwick to Lawrence. But in thinking about stare decisis, which is obviously the core of this case, how should we be thinking about it? I mean, Justice Breyer pointed out that in Casey, and in some respects, well, it was a different conception of stare decisis insofar as it very explicitly took into account public reaction. Is that a factor that you accept? Or are you arguing that we should minimize that factor? And is there a different set of rules? It is true that Casey identified Brown and West Coast Hotel as watershed decisions, but is there a distinct set of stare decisis considerations applicable to what the court might decide as a watershed decision?
I don't think there should be a distinct set of considerations there, Your Honor. I think what I emphasize, and just to make sure, on the kind of legitimacy, the court looking outward, I think Casey was unusual in that regard. I think it was a mistake, and I think it's something that is kind of in conflict with this court's structure and approach as an independent branch, looking to the Constitution rather than looking without. And I think that's one reason why traditionally the court is in some of its greatest overrulings, it's not looking without. It's saying this was wrong. It was wrong the day it was decided. We know it's wrong today, and it's led to all these terrible consequences. We should get rid of it. So I think that was an unfortunate break, and I think the court Even if the court were to still look at legitimacy, though, Justice Barrett, I think the court could very, very powerfully say, look, our legitimacy really derives from our willingness to stand strong and stand firm in the face of whatever is going on, and stand for constitutional principle and follow our traditional stare decisis factors to overrule when it's appropriate. Thank you, Your Honor.
Thank you, counsel.
Thank you, Mr. Chief Justice.
Ms. Rickleman?
Mr. Chief Justice, and may it please the court, Mississippi's ban on abortion 2 months before viability is flatly unconstitutional under decades of precedent. Mississippi asks the court to dismantle this precedent and allow states to force women to remain pregnant and give birth against their will. The court should refuse to do so for at least 3 reasons. First, stare decisis presents an especially high bar here. In Casey, this court carefully examined and rejected every possible reason for overruling Roe, holding that a woman's right to end a pregnancy before viability was a rule of law and a component of liberty it could not renounce. The question then is not whether Roe should be overturned, but whether Casey was egregiously wrong to adhere to Roe's central holding. Second, Casey and Roe were correct. For a state to take control of a woman's body and demand that she go through pregnancy and childbirth with all the physical risks and life-altering consequences that brings is a fundamental deprivation of her liberty. Preserving a woman's right to make this decision until viability protects her liberty while logically balancing the other interests at stake. Third, eliminating or reducing the right to abortion will propel women backwards. 2 generations have now relied on this right, and 1 out of every 4 women makes the decision to end a pregnancy. Mississippi's ban would particularly hurt women with a major health or life change during the course of a pregnancy, poor women who are twice as likely to be delayed in accessing care, and young people or those in contraception who take longer to recognize a pregnancy. To avoid profound damage to women's liberty, equality, and the rule of law, the court should affirm.
Counsel, I just have one question. I assume you, from your brief, you're relying on an autonomy theory.
Both bodily integrity and the ability to make decisions related to family, marriage, and childbearing, Your Honor.
Shortly, some years after we decided Casey, we had a case out of South Carolina, I believe, involved a woman who had been convicted of criminal child neglect because she ingested cocaine during pregnancy. In her case was post-viability, so it doesn't fit in the facts of this case. If she had ingested cocaine pre-viability and had the same negative consequences to her child, do you think the state had an interest in enforcing that law against her?
The state may have, Your Honor. The state can certainly regulate to serve its interests in fetal life and in women's health. Those particular laws tend to undermine both of those interests because they deter women from seeking prenatal care, which is counterproductive to both their health.
But the pre-viability as well as post-viability?
No, Your Honor. The court has been clear that after viability, states can prohibit abortion except to save a woman's life.
No, I mean in my example of criminal child neglect. I understand your argument is about abortion. I am trying to look at the issue of bodily autonomy and whether or not she has a right also to bodily autonomy in the case of ingesting an illegal substance and causing harm to a pre-viability fetus.
Your Honor, of course, those issues aren't posed in this case. And again, I would say that the states can certainly regulate throughout pregnancy, both before and after viability, to preserve fetal life and to preserve the woman's health. The court has said, however, there are other constitutional issues at stake, for instance, in the Ferguson case, that states still can't violate women's Fourth Amendment rights. But again, that's not what this case is about. This case is about a ban on abortion that the state concedes is weeks before viability. And the court has been clear for 50 years that the one thing that states cannot do is to take the decision completely away from the woman until viability. Then until that point, it is her decision to make, given the unique physical demands of pregnancy and the life-altering consequences of pregnancy and having a child.
Thank you.
The point you made about the impact on women and their place in society, those were certainly made in Roe as well. What we have before us, though, is a 15-week standard. Are you suggesting that the difference between 15 weeks and viability are going to have the same sort of impacts as you were talking about, or as we were talking about in Roe?
Yes, Your Honor, I believe they would, because people who need abortion after 15 weeks are often in the most challenging circumstances. As I mentioned, there are people who have perhaps had a major health or life change, a family illness, a job loss, a separation, young people or people who are on contraception or pregnant for the first time and who are delayed in recognizing the signs of pregnancy, or poor women who often have much more trouble navigating access to care. And if they're denied the ability to make this decision because there's a ban after 15 weeks, they will suffer all of the consequences that the court has talked about in the past. And in fact, the data has been very clear over the last 50 years that abortion has been critical to women's equal participation in society. It's been critical to their health, to their lives, their ability to pursue.
I'm sorry, what kind of data is that?
I would refer the court to the brief of The Economist in this case, Your Honor, and it compiles data showing studies based actually on causal inference, showing that it's the legalization of abortion and not other changes that have had these benefits for women in society. And again, those benefits are clear for education, for the ability to pursue a profession, for the ability to have—
putting that data aside, if you think that the issue is one of choice, that women should have a choice to terminate their pregnancy, that supposes that there is a point at which they've had the fair choice, opportunity to choice. And why would 15 weeks be an inappropriate line? So viability, it seems to me, doesn't have anything to do with choice. But if it really is an issue about choice, why is 15 weeks not enough time?
For a few reasons, Your Honor. First, the state has conceded that some women will not be able to obtain an abortion before 15 weeks, and this law will bar them from doing so. And a reasonable possibility standard would be completely unworkable for the courts. It would be both less principled and less workable than viability. And some of the reasons for that are, without viability, there will be no stopping point. States will rush to ban abortion at virtually any point in pregnancy. Mississippi itself has a 6-week ban that it's defending with very similar arguments as it's using to defend the 15-week ban. And there are states that have bans.
Well, I know, but I'd like to focus on the 15-week ban because that's not a dramatic departure from viability. It is the standard that the vast majority of other countries have. When you get to the viability standard, we share that standard with the People's Republic of China and North Korea. And I don't think you have to be in favor of looking to international law to set our constitutional standards to be concerned if those are share that particular time period.
I think there's two questions there, Your Honor, if I may. First, that is not correct about international law. In fact, the majority of countries that permit legal access to abortion allow access right up until viability, even if they have nominal lines earlier. So, for example, Canada, Great Britain, and most of Europe allows access to abortion right up until viability, and it also doesn't have the same barriers in place.
What do you mean, even if they have nominal lines earlier?
Some countries, Your Honor, have a nominal line of 12 weeks or 18 weeks, but they permit legal access to abortion after that point for broad social reasons, health reasons, socioeconomic reasons. So their regimes really aren't comparable, and they also don't have the same types of barriers that we have here. So if the court were to move the line substantially backwards, and 15 weeks is 9 weeks before viability, Your Honor, it's quite a bit backwards. It may need to reconsider the rules around regulations, because if it's cutting the time period to obtain an abortion roughly in half, then those barriers are going to be much more important.
Thank you.
Ms. Rickelman, I have a question about the safe haven laws. So petitioner points out that in all 50 states, you can terminate parental rights by relinquishing a child after abortion. And I think the shortest period might have been 48 hours, if I'm remembering the data correctly. So it seems to me, seen in that light, both Roe and Casey emphasized the burdens of parenting. And insofar as you and many of your amici focus on the ways in which the forced parenting, forced motherhood would hinder women's access to the workplace and to equal opportunities. It's also focused on the consequences of parenting and the obligations of motherhood that flow from pregnancy. Why don't the safe haven laws take care of that problem? It seems to me that it focuses the burden much more narrowly. There is, without question, an infringement on bodily autonomy, which we have in other contexts like vaccines. However, it doesn't seem to me to follow that pregnancy and then parenthood are all part of the same burden. And so it seems to me that the choice more focused would be between, say, the ability to get an abortion at 23 weeks or the state requiring the woman to go 15, 16 weeks more and then terminate parental rights at the conclusion. Why didn't you address the safe haven laws, and why don't they matter?
I think they don't matter for a couple of reasons, Your Honor. First, even if some of those laws are new since Casey, the idea that a woman could place a child up for adoption has, of course, been true since Roe. So it's a consideration that the court already had before it when it decided those cases and adhered to the viability line. But in addition, we don't just focus on the burdens of parenting, and neither did Roe and Casey. Instead, pregnancy itself is unique. It imposes unique physical demands and risk on women, and in fact has impact on all of their lives and their ability to care for other children, other family members, on their ability to work. And in particular, in Mississippi, those risks are alarmingly high. It's 75 times more dangerous to give birth in Mississippi than it is to have a pre-viability abortion. And those risks are disproportionately threatening the lives of women of color.
So are you saying, I mean, actually, as I read Roe and Casey, they don't talk very much about adoption. It's a passing reference that means out of the obligations of parenthood. But as I hear this answer, then are you saying that the right, as you conceive of it, is grounded primarily in the bearing of the child, in the carrying of pregnancy, and not so much looking forward into the consequences on professional opportunities and work life and economic burdens?
No, Your Honor, I believe it's both, and that is exactly how Casey talked about it. It talked about the two strands of cases that supported the right. One was the strand of cases supporting bodily integrity, and it cited to cases like Cruzan and Riggins versus Nevada. And the second was the strand of cases supporting decisional autonomy, and specifically decisions related to childbearing, marriage, and procreation, decisions like Griswold, Loving. And so it's really both strands that we're relying on here.
May I ask you a question about stare decisis, counsel? Your colleagues on the other side have emphasized that Casey rejected Roe's trimester framework and replaced it with an undue burden standard. They argue that the undue burden standard was not well known to the law before that. And then they argue that the undue burden standard has evolved over time, too, in ways that the court has found difficult to agree upon. In Hellerstedt, for example, they point out in their briefs that the court seemed to suggest that a court should consider both the benefits and the burdens associated with the proposed restriction. In June Medical, more recently, the court splintered on that same question, whether benefits could be considered or only burdens. And so the argument goes that this has proved to be putting aside all the other obviously difficult questions in the case, that the standard itself has proved difficult to administer, and that is relevant to the stare decisis analysis. And I just wanted to give you an opportunity to respond.
Yes, Your Honor. The first point I'd like to make is the undue burden test is not at issue in this case. That is the test that applies to regulations, not prohibitions, and the state has conceded that this is a prohibition. In fact, that's the title of this law, is an act to prohibit abortion after 15 weeks. And the only thing that's at issue in this case is the viability line, and the viability line has been enduringly workable. The lower federal courts have applied it consistently and uniformly for 50 years, and the Fifth Circuit here below had no difficulty striking down this law unanimously 3-0. So it's been an exceedingly workable standard. And if I may return to your question, Mr. Chief Justice, a reasonable possibility standard would not be workable. It would ultimately boil down to an argument that states can prohibit a category of women from exercising a constitutional right merely because of the number of people in the category, and that's just not how constitutional rights work. A state would never say that it could ban religious services on a Wednesday evening, for example, simply because most people could attend religious services on another night of the week.
So I actually just wanted to, that's helpful, I think. I just want to make sure I understand what you're telling me, counsel, that if the court were to, in this case, step past viability and apply undue burden, the undue burden test to regulations prior to viability, you would agree with the other side, I think, that that's not a workable standard. Is that a fair understanding of what you're telling the court?
No, Your Honor. I believe
think that would be workable?
I believe that, if I may clarify, I believe the undue burden test has been workable for regulations.
I understand that. If it were to apply, if the court were to, and I thought this is what you were saying in response to the Chief Justice, but maybe I'm mistaken. Please correct me if I am, but what is your argument against applying the undue burden standard prior to viability?
If the undue burden standard, as this court laid out in Casey, which includes the viability line, is applied.
I'm asking, I know we're fighting the hypothetical here, counsel, all right? Accept the hypothetical. Hypothetically, the court were to extend the undue burden standard to regulations prior to viability. Would that be workable, or would that not be workable in your view?
Without viability, it would not be workable, Your Honor, because it would ultimately, again, always come down to a claim that states can bar a certain category of people from exercising this right simply because of the number of people in the category. And that's not a workable standard, and it's not a constitutional.
I appreciate that clarification. Thank you.
Just to follow up on that, I read your brief to say that the only real options we have are to reaffirm Roe and Casey as they stand, or to overrule them in their entirety. You say that, quote, there are no half measures here. Is that a correct understanding of your brief?
Your Honor, it's certainly the arguments that the state has presented is what we're responding to there, which is that all of the state's arguments, including their alternatives, which are undue burden without viability, would be the equivalent of overruling Casey and Roe, because the viability line is the central holding of those cases. Casey mentioned it no fewer than 19 times, and the court in June Medical just a year ago affirmed that the viability line is the central holding of both Casey and Roe.
Well, you do emphasize that the court drew the line at viability in Roe and reaffirmed that in Casey, and that is certainly something that we have to take very seriously into consideration. But suppose we were considering that question now for the first time. I'm sure you know the arguments about the viability line as well as I do, probably better than I do. What would you say in defense of that line? What would you say to the argument that has been made many times by people who are pro-choice and pro-life that the line really doesn't make any sense, that it is, as Justice Blackmun himself described it, arbitrary? If a woman wants to be free of the burdens of pregnancy, that interest does not disappear the moment the viability line is crossed. Isn't that right?
No, Your Honor. And if I may make a few points to answer your question. First, I think the state views viability as arbitrary because it completely discounts the woman's interest. But viability—
No, but does a woman have, upon reaching the point of viability, does not the woman have the same interest that she had before viability in being free of this pregnancy that she no longer wants to continue?
Viability is a principled line, Your Honor, because in ordering the
I'm trying to
interest...
see whether it is a principled line.
Yes,
you agree with me at least on that point, that a woman still has the same interest in terminating her pregnancy after the viability line has been crossed.
Yes, Your Honor, but the court balanced the interest, and in ordering the interest at stake...
interest on the other side. The fetus has an interest in having a life, and that doesn't change, does it, from the point before viability to the point after viability?
In some people's view, it doesn't, Your Honor, but what the court said is that those philosophical differences couldn't be resolved in a way...
That's what I'm getting at. What is the philosophical argument, the secular philosophical argument for saying this is the appropriate line? There are those who say that the rights of personhood should be considered to have taken hold at a point when the fetus acquires certain independent characteristics. But viability is dependent on medical technology and medical practice. It has changed. It may continue to change.
No, Your Honor, it is principled because in ordering the interest at stake, the court had to set a line between conception and birth, and it logically looked at the fetus's ability to survive separately as a legal line because it's objectively verifiable and doesn't require the court to resolve the philosophical issues at stake.
I just want to focus on stare decisis for a little bit. I found my colleague Justice Breyer's comments quite compelling. I'm not quite sure how they play out in Casey. It is certainly true that we cannot base our decisions on whether they're popular or not with the people. Casey seemed to say we shouldn't base our decisions not only on that, but whether they're going to seem popular. And it seemed to me to have a paradoxical conclusion that the more unpopular the decisions are, the firmer the court should be in not departing from prior precedent. It's sort of a super stare decisis, but it's super stare decisis for what are regarded as, by many, as the most erroneous decisions. Do you think there is that category, or is it just normal stare decisis?
I think it is precedent on precedent, Your Honor, because Casey did the stare decisis analysis for Roe. So the question before this court is whether that stare decisis analysis was egregiously wrong. And if I may answer your earlier question about whether viability was squarely at issue in Casey, it clearly was, Your Honor. At pages 869 to 871, the court squarely addressed viability because the government had made the argument that viability was arbitrary.
I appreciate that Casey addressed it, but that's different than saying it was at issue. It said it was the central principle of Roe because it was pretty much all that was left after they were done dealing with the rest of it. And the regulations in Casey had no applicability or not depending upon where viability was. They applied throughout the whole range, period. So if they didn't say anything about viability, it's like what Justice Blackmun said when discussing among his colleagues, which is a good reason not to have papers out that early, is that they don't have to address the line drawing at all in Roe. And they didn't have to address the line drawing at all in Casey.
I disagree with that, Your Honor, because the undue burden test incorporates the viability line. That was what the court was assessing the regulations against, whether they imposed a substantial obstacle in the path of a woman before viability. And if a prohibition like this law isn't a substantial obstacle, then nothing would be. So the issue was squarely before the court. And in fact, the court said at page 879 that in adopting the undue burden test, it was not disturbing the viability line.
It's a very interesting question that I think Justice Barrett raised too. It's usually just philosophical, but I think it has bite here. When I read Casey, it's not just one-on-one, two is greater than one. Yeah, Casey plus Roe is greater than. They're making a point that we're an institution perhaps more than a court of appeals or a district court. It's Hamilton's point, no purse, no sword, and yet we have to have public support. And that comes primarily, says Casey, I wonder if it was O'Connor who wrote that. I don't know. But it comes primarily from people believing that we do our job, we use reason, we don't look to just what's popular. And that's where you're seeing the paradox. But the problem with the super case, of which we've heard 3 mentioned, the problem with the super case like this, the rare case, the watershed case, where people are really opposed on both sides, and they really fight each other, is they're going to be ready to say, no, you're just political, you're just politicians. And that's what kills us as an American institution. That's what they're saying. So we're looking at it for that, but we are looking to, and that, they say, is a reason why. A reason why, when you get a case like that, you better be damn sure that the normal stare considerations, stare decisis overruling are really there in spades, double, triple, quadruple, and then they go through and show they're not. Okay? What's the paradox? Maybe you think I've just made an argument that there isn't one, but really, in my head, I'm thinking I'm not sure. There may be one, and I don't know if you've ever thought about this. I don't know if you've ever, when that occurred to you. I don't want to overrule the stare. I wouldn't want the court to overrule the stare decisis section of Casey. You say, and that's what I think is being brought up, and maybe I haven't made it clearer, but I've tried to.
Yes, Your Honor. I think the point that the court was making was that the fact that some states may continue to enact laws in the teeth of the court's precedent has never been enough of a reason to overrule. And that's true for a number of decisions that the court has issued. The fact that some people continue to disagree with them is not a basis to discard that precedent.
Justice Thomas, anything further?
Back to my original question. If I know your interest here is in abortion, I understand that. But if I were to ask you what constitutional right protects the right to abortion, is it privacy? Is it autonomy? What would it be?
It's liberty, Your Honor. It's the textual protection in the 14th Amendment that a state can't deprive a person of liberty without due process of law. And the court has interpreted liberty to include the right to make family decisions and the right to physical autonomy, including the right to end a pre-viability pregnancy.
So it's all of the above.
Well, that's how the court has interpreted the Liberty Clause for over 100 years in cases going back to Meyer, Griswold, Carey, Loving, Lawrence.
Yeah, but I mean, all of those sort of just come out of Lochner. So it's we've dropped part of it. So I understand what you're saying, but what I'm trying to focus on is to lower the level of generality, or at least be a little bit more specific. In the old days, we used to say it was a right to privacy that the court found in the due process, substantive due process clause. Okay. So, or in substantive due process. And I'm trying to get you to tell me, what are we relying on now? Is it privacy? Is it autonomy? What is it?
I think it continues to be liberty, and the right exists whatever level of generality the court applies. There was a tradition under the common law for centuries of women being able to end their pregnancies. But in addition, when it comes to decisions related to family, marriage, and childbearing, the court has done the analysis at a higher level of generality. And that makes sense because otherwise the Constitution would reinforce the historical discrimination against women.
Thank you. Justice Breyer? Justice Alito?
Well, you just mentioned the common law. So let me ask you a couple of questions about history. Did any state constitutional provision recognize that abortion was a right, liberty, or immunity in 1868 when the 14th Amendment was adopted?
No, Your Honor, but it had been allowed under the common law for many years.
Does any judicial decision at that time or shortly or immediately after 1868 recognize that abortion was a right, liberty, or immunity?
There were state high court decisions shortly before then, Your Honor, talking about the ability of women to end a pregnancy before quickening.
What's your best case?
For the right to end a pregnancy, Your Honor?
Mm-hmm.
Allowing a state to take control of a woman's body and force her to undergo the physical demands, risks, and life-altering consequences of pregnancy is a fundamental deprivation of her liberty. And once the court recognizes that that liberty interest deserves heightened protection, it does need to draw a workable line, and viability is a line that logically balances the interests at stake.
The brief for the American Historical Association says that abortion was not legal before quickening in 26 out of 37 states at the time when the 14th Amendment was adopted. Is that correct?
That is correct, because some of the states had started to discard the common law at that point because of a discriminatory view that a woman's proper role was as a wife and mother, a view that the Constitution now rejects, and that's why it's appropriate to do the historical analysis at a higher level of generality.
In the face of that, can it be said that the right to abortion is deeply rooted in the history and traditions of the American people?
Yes, it can, Your Honor. Again, at the founding, women were able to end their pregnancy under the common law. And in fact, this court in Glucksburg specifically discussed Casey as a decision based on history and tradition. And at note 19 specifically called out and relied on Roe's conclusion that at the time of the founding and well into the 1800s, women had the ability to end a pregnancy.
What was the principal source that the court relied on in Roe for its historical analysis? Who was the author of that article?
I apologize, Your Honor, I don't remember the author. I know that the court spent many pages of the opinion doing a historical analysis. There's also a brief on behalf of several key American historian associations that go through that history in detail, because there's even more information now that supports Roe's legal conclusions.
All right, thank you.
I think the other side would say that the core problem here is that the court has been forced by the position you're taking and by the cases to pick sides on the most contentious social debate in American life, and to do so in a situation where they say that the Constitution is neutral on the question of abortion, the text and history, that the Constitution's neither pro-life nor pro-choice on the question of abortion. And they would say, therefore, it should be left to the people, to the states, or to Congress. And I think they also then continue, because the Constitution is neutral, that this court should be scrupulously neutral on the question of abortion, neither pro-choice nor pro-life. But because they say the Constitution doesn't give us the authority, we should leave it to the states, and we should be scrupulously neutral on the question. And that they are saying here, I think, that we should return to a position of neutrality on that contentious social issue, rather than continuing to pick sides on that issue. So I think that's, at a big picture level, their argument. I want to give you a chance to respond to that.
Yes, a few points, if I may, Your Honor. First, of course, those very same arguments were made in Casey, and the court rejected them, saying that this philosophical disagreements can't be resolved in a way that a woman has no choice in the matter. And second, I don't think it would be a neutral position. The Constitution provides a guarantee of liberty. The court has interpreted that liberty to include the ability to make decisions related to childbearing, marriage, and family. Women have an equal right to liberty under the Constitution, Your Honor, and if they're not able to make this decision, if states can take control of women's bodies and force them to endure months of pregnancy and childbirth, then they will never have equal status under the Constitution.
And I want to ask a question about stare decisis and to think about how to approach that here, because there have been lots of questions picking up on Justice Barrett's questions and others. And history helps think about stare decisis as I've looked at it, and the history of how the courts applied stare decisis. And when you really dig into it, history tells a somewhat different story, I think, than is sometimes assumed. If you think about some of the most important cases, the most consequential cases in this court's history, there's a string of them where the cases overruled precedent. Brown v. Board, outlawed separate but equal. Baker versus Carr, which set the stage for one person, one vote. West Coast Hotel, which recognized the state's authority to regulate business. Miranda versus Arizona, which required police to give warnings when about the right to remain silent and to have an attorney present to suspects in criminal custody. Lawrence v. Texas, which said that the state may not prohibit same-sex conduct. Knapp versus Ohio, which held that the exclusionary rule applies to state criminal prosecutions to exclude evidence obtained in violation of the Fourth Amendment. Gideon versus Wainwright, which guaranteed the right to counsel in criminal cases. Obergefell, which recognized a constitutional right to same-sex marriage. In each of those cases, and that's a list, and I could go on, and those are some of the most consequential and important in the court's history, the court overruled precedent. And it turns out if the court in those cases had listened and they were presented with arguments in those cases, adhere to precedent. In Brown v. Board, adhere to Plessy. In West Coast Hotel, adhere to Atkins and adhere to Lochner. And if the court had done that in those cases, the country would be a much different place. So I assume you agree with most, if not all, the cases I listed there where the court overruled precedent. So the question on stare decisis is why, and I know you disagree with what I'm about to say in the if we think that the prior precedents are seriously wrong, why then doesn't the history of this court's practice with respect to those cases tell us that the right answer is actually to return to the position of neutrality and not stick with those precedents in the same way that all those other cases didn't?
Because the view that a previous precedent is wrong, Your Honor, has never been enough for this court to overrule, and it certainly shouldn't be enough here when there's 50 years of precedent. Instead, the court has required something else, a special justification, and the state doesn't come forward with any special justification. It makes the same exact arguments the court already considered and rejected in its stare decisis analysis in Casey, and in fact, there is nothing different. There is no less need today than 30 years ago or 50 years ago for women to be able to make this fundamental decision for themselves about their bodies, lives, and health.
Thank you.
Justice Barrett?
I want to ask you a follow-up question. The Chief was asking you about the viability line and if that was the right place, if that's the right line to draw. So let's take it out of the question of stare decisis and imagine that there's a state constitution that's identical to the 14th Amendment's due process clause. And a state Supreme Court has to decide as a matter of state constitutional law what the scope of an abortion right is. And the second trimester ends at 27 weeks. And so that state Supreme Court says, we think that the right exists, in an absolute sense that the state cannot take away the right up to 27 weeks. And then after that adopts an undue burden standard. As a matter of first principles, is that line acceptable as a matter of constitutional law?
Your Honor, it may be, but I think that the question in this case is whether a line is obviously more principled or obviously more workable than viability because of the stare decisis context.
That's the Roe framework, basically the trimester. Why wouldn't that be workable if you pick a line and say the end of the second trimester, 27 weeks, third trimester, state's interests increase? I don't understand why 27 weeks is less workable than 24.
I'm not trying to suggest it is, Your Honor. And what I was trying to suggest is that the viability line is a principled and workable line. So to change it, there would have to be a new line that's obviously more principled and more workable. And the line that the court has drawn actually—
But that's stare decisis. I'm asking as a matter of first principles.
As a matter of first principle, the viability line makes sense because if the state constitution is the same—
As a matter of prudential judgment, it's not constitutionally required as a matter of first principles because in fact, we could decide to be more protective and say 27 weeks end of the second trimester.
You could, Your Honor, but the viability line makes sense given the protection for liberty because it comes from the woman's liberty interest in resisting state control of her body. And once the court recognizes that interest, it does need to draw a line, as it does in many other constitutional contexts, like the Fourth and Fifth Amendment. And the viability line, as I mentioned, makes sense because it focuses on the fetus's ability to survive separately, which is an appropriate legal line because it's objectively verifiable and doesn't delve into philosophical questions about when life begins.
Thank you, counsel. General Prelogger.
Mr. Chief Justice, and may it please the court. For a half century, this court has correctly recognized that the Constitution protects a woman's fundamental right to decide whether to end a pregnancy before viability. That guarantee that the state cannot force a woman to carry a pregnancy to term and give birth has engendered substantial individual and societal reliance. The real-world effects of overruling Roe and Casey would be severe and swift. Nearly half of the states already have or are expected to enact bans on abortion at all stages of pregnancy, many without exceptions for rape or incest. Women who are unable to travel hundreds of miles to gain access to legal abortion will be required to continue with their pregnancies and give birth, with profound effects on their bodies, their health, and the course of their lives. If this court renounces the liberty interest recognized in Roe and reaffirmed in Casey, it would be an unprecedented contraction of individual rights and a stark departure from principles of stare decisis. The court has never revoked a right that is so fundamental to so many Americans and so central to their ability to participate fully and equally in society. The court should not overrule this central component of women's liberty.
General, would you specifically tell me, state what the right is? Is it specifically abortion? Is it liberty? Is it autonomy? Is it privacy?
The right is grounded in the liberty component of the 14th Amendment, Justice Thomas, but I think that it promotes interests in autonomy, bodily integrity, liberty, and equality. And I do think that it is specifically the right to abortion here, the right of a woman to be able to control without the state forcing her to continue a pregnancy, whether to carry that baby to term.
I understand we're talking about abortion here, but what is confusing is that if we were talking about the Second Amendment, I know exactly what we're talking about. If we're talking about the Fourth Amendment, I know what we're talking about because it's written, it's there. What specifically is the right here that we're talking about?
Well, Justice Thomas, I think that the court in those other contexts with respect to those other amendments has had to articulate what the text means in the bounds of the constitutional guarantees. And it's done so through a variety of different tests that implement First Amendment rights, Second Amendment rights, Fourth Amendment rights. So I don't think that there is anything unprecedented or anomalous about the right that the court articulated in Roe and Casey and the way that it implemented that right by defining the scope of the liberty interest by reference to viability and providing that that is the moment when the balance of interest tips and when the state can act to prohibit a woman from getting an abortion based on its interest in protecting the fetal life at that point.
So the right specifically is abortion.
It's the right of a woman prior to viability to control whether to continue with a pregnancy, yes.
Thank you.
General, I am interested in Justice Kavanaugh's long litany of cases in which we've overruled precedent, and we have. Yet you did call this unprecedented. As I see the structure of the Constitution, the body of it is the relationship of the three branches of government. And then there is the relationship of the federal government to the state. And through our incorporation of the 14th Amendment of the state vis-a-vis the individual, it's the federal government and the state's relationship to individuals. And I see the Bill of Rights, including the 14th Amendment, as basically setting the limits, giving individual freedom to do certain things. and stopping the government from intruding in those liberties, in those Bill of Rights, correct? Of all of the decisions that Justice Kavanaugh listed, all of them virtually except for maybe one, involved us recognizing and overturning state control over issues that we said belong to individuals. The right in Miranda to be warned was an individual right, correct?
That's right, Justice Sotomayor. And I think that that is a key distinction with the list of precedents that Justice Kavanaugh was relying on. I think that there are really two key distinctions. And the first is that in the vast majority of those cases, the court was actually taking the issue away from the people and saying that it had been wrong before not to recognize a right. And I think that matters because it goes straight to reliance interests. Here, the court would be doing the opposite. It would be telling the women of America that it was wrong, that actually the ability to control their bodies and perhaps the most important decision they can make about whether to bring a child into this world is not part of their protected liberty. And I think that that would come at tremendous cost to the reliance that women have placed on this right and on societal reliance and what this right has meant for further ensuring
reliance
equality.
Point is a good point, and this may be my fault. I'm talking about pages 854 to 863 in the Casey case. And I've already used up too much time. I can't read those pages out loud. But they do not include the list that Justice Kavanaugh had. They do include two. One is Brown, and the second one is West Coast Hotel versus Parrish. And you could add the gay rights cases as a third, which would fit the criteria. But there are complex criteria that she's talking about that link to the position in the rule of law of this court. So all I would say is you have to read them before beginning to say whether they are overruling or not overruling in the sense meant there, calling for special concern. Now, they say in those, maybe I'd mention too. Wait a minute. Of course, Plessy was wrong when decided, but just a minute. Also remember, Plessy said that separate but equal was a badge of inferiority. No, they said it isn't. Well, all you have to do is open your eyes and look at the South, my friend, and you will see whether it was or it wasn't in 1954. And they made a similar point. They said, are you going to sit here in the middle of the Depression and tell me that Lochner, with its other cases, and pure, just about pure laissez-faire, that we can run the country that way? I mention that because I want people to read those 15 pages with care. And that's why I said that. If you had anything to add to my plea to read it, please do.
Well, Justice Breyer, I agree completely. I have read those pages and reread them many times, and I think that this is actually another key distinction from the cases that Justice Kavanaugh was referring to, and that is, as I understand those passages in Casey, the court carefully walked through each and every stare decisis factor that this court focuses on. It looked at workability of the viability rule, doctrinal underpinnings, legal and factual developments, and critically reliance interests. And down the line, it found that the case for reaffirming Roe was overwhelming. And in that situation, when every factor that the court consults to determine whether to retain precedent counsels in favor of retaining it, I think Casey properly perceived that a decision to overrule nevertheless, perhaps based on conclusion that the justices thought the case was wrongly decided in the first instance, would run counter to the ability of stare decisis to function as a cornerstone of the rule of law in this context.
Is it your argument that a case can never be overruled simply because it was egregiously wrong?
I think that at the very least, the state would have to come forward with some kind of materially changed circumstance or some kind of materially new argument, and Mississippi hasn't done so in this case.
So suppose Plessy versus Ferguson was re-argued in 1897, so nothing had changed. Would it not be sufficient to say that was an egregiously wrong decision on the day it was handed down, and now it should be overruled?
It certainly was egregiously wrong on the day that it was handed down, Plessy, but what the court said in analyzing Plessy to Brown and Casey was that what had become clear is that the factual premise that underlay the decision, this idea that segregation didn't create a badge of inferiority, had been entirely mistaken.
So
and
is it your answer that we needed all the experience from 1896 to 1954 to realize that Plessy was wrongly decided? Would you answer my question? Had it come before the court in 1897, should it have been overruled or not?
I think it should have been overruled, but I think that the factual premise was wrong in the moment it was decided, and the court realized that and clarified that when it overruled.
So there are circumstances in which a decision may be overruled, properly overruled, when it must be overruled, simply because it was egregiously wrong at the moment it was decided.
Well, I think every other stare decisis factor likewise would have justified overruling in that interest, that actually it would run counter to any notion of reasonable reliance, that it was not a workable rule, that it had become an outlier in our understanding of fundamental freedoms.
Well, there was a lot of reliance on, there was a lot of reliance on Plessy. The South built up a whole society based on the idea of white supremacy. So there was a lot of reliance. It was improper reliance. It was reliance on an egregiously wrong understanding of what equal protection means. But your answer is, I still don't understand. I still don't have your answer clearly. Can a decision be overruled simply because it was erroneously wrong, even if nothing has changed between the time of that decision and the time when the court is called upon to consider whether it should be overruled? Yes or no? Can you give me a yes or no answer on that?
This court, no, has never overruled in that situation just based on a conclusion that the decision was wrong. It has always applied the stare decisis factors and likewise found that they warrant overruling in that instance. And Casey did that. It applied the stare decisis factors. If stare decisis is to mean anything, it has to mean that that kind of extensive consideration of all of the same arguments for whether to retain or discard a precedent itself is an additional layer of precedent that needs to be relied on and can form a stable foundation of the rule of law.
General, you've talked a number of times about the reliance interests here, and I think I'd like you to say a little bit more about that, because, you know, sometimes when we talk about reliance interests, it's like there's a rule of law and you look at it and you say, oh, somebody will enforce my contract because of this rule, and it has a very kind of grounded quality to it. And as Casey talked about the reliance interests here, they're a little bit more airy. And I just wanted to get your sense of what are the reliance interests here, and how do they cash out on the ground?
Well, there are multiple reliance interests here, as I think Casey correctly recognized. Casey pointed to the individual reliance of women and their partners who had been able to organize their lives and make important life decisions against the backdrop of having control over this incredibly consequential decision whether to have a child. And people make decisions in reliance on having that kind of reproductive control, decisions about where to live, what relationships to enter into, what investments to make in their jobs and careers. And so I think on a very individual level, there has been profound reliance. And it's certainly the case that not every woman in America has needed to exercise this right or has wanted to, but 1 in 4 American women have had an abortion. And for those women, the right secured by Roe and Casey has been critical in ensuring that they can control their bodies and control their lives. And then I think there's a second dimension to it that Casey also properly recognized, and that's the societal dimension. That's the understanding of our society, even though this has been a controversial decision, that this is a liberty interest of women. It's the case that not everyone agrees with Roe versus Wade, but just about every person in America knows what this court held. They know how the court has defined this concept of liberty for women and what control they will have in the situation of an unplanned pregnancy. And for the court to reverse course now, I think would run counter to that societal reliance and the very concept we have of what equality is guaranteed to women in this country.
It is certainly true that there can be some planning by some people about pregnancy. People who are raped don't have a choice, whether it's by an outsider or their own husband. And not everybody can afford contraceptives, contrary to your adversary's brief. In fact, 19% of the women in Mississippi are uninsured, so they don't have money to pay for contraceptives. So, but why their point in their brief was, contraceptives, if you use them, the failure rate is very small, et cetera, et cetera. How can there be real reliance? So could you address that issue?
Of course. So first, this is not a new circumstance since Roe and Casey. Contraceptives existed in 1973 and in 1992, and still the court recognized that unplanned pregnancies would persist and deeply implicate the liberty interest of women. But I think even on the facts, the state is mistaken here. A contraceptive failure rate in this country is at about 10% using the most common methods. That means that women using contraceptives, approximately 1 in 10 will experience an unplanned pregnancy in the first year of use alone. About half the women who have unplanned pregnancies were on contraceptives in the month that occurred. And so I think the idea that contraceptives could make the need for abortion dissipate is just contrary to the factual reality.
You also mentioned, or maybe it was your co-counsel, that life changes for women after 15 weeks.
That's exactly right, Justice Sotomayor. And I think that this is responsive as well to the questions that the Chief Justice was asking about, in particular, the impact of enforcing a 15-week bar in this case. The court has always looked at that issue by looking at the people for whom the law is a restriction, not those for whom it's irrelevant. So the question is, why would women need access to abortion after 15 weeks, and what is the effect on them? And there are any number of women who cannot get an abortion earlier. They don't realize that they're pregnant. That's especially true of women who are young or don't haven't experienced a pregnancy before, or their life circumstances change, as you referred to, Justice Sotomayor. They lose their job, or their relationship breaks apart, or they have medical complications. Or for many women, they don't have the resources to pay for it earlier. It takes time for them to raise the money or make the appropriate logistical arrangements to be able to take time off work and travel and have childcare. And for all those women in this category who need access to abortion after 15 weeks, the fact that other women were able to exercise their constitutional rights does nothing to diminish the impact on their liberty interests in forcing them to continue with that pregnancy.
Thank you.
General, following up on that, would that argument be true in terms of viability as well? In other words, what your discussion of the reliance interests and the ability of women and men to control their lives in reliance on the right to an abortion, the argument would not be as strong, I think you'll have to concede, given what we're talking about, which is not a prohibition, it's a 15-week line. Is that right?
Yes.
You have to hypothesize people who have planned their lives according to a 24 or whatever week limit it is, but not a 15-week limit on abortion, right?
Well, I don't think the court has ever analyzed reliance with that kind of parsing. I think here the force of the viability line is that it's clearly demarcated the scope of a woman's protected liberty interest in this context. And the state is not actually asking this court to replace it with a clear 15-week line that would provide some measure of continued protection for this right. They're asking the court to reverse the liberty interest altogether or leave it up in the air. And if that were to happen, then immediately states with 6-week bans, 8-week bans, 10-week bans, and so on would seek to enforce those with no continued guidance of what the scope of the liberty interest is going forward.
Well, that may be what they're asking for, but the thing that is at issue before us today is 15 weeks. And I just wonder what the strength of your reliance arguments, which sounded to me like being based on a total prohibition, would be if there isn't a total prohibition. And as far as viability goes, I don't see what that has to do with the question of choice at all.
Well, I think as Casey emphasized in reaffirming the viability line, the court justified that as having both a logical and a biological justification that it marks the point in pregnancy when the fetus is capable of meaningful life.
That's what John Hart Ely explained was a complete syllogism. That's the definition of viability. It's not a reason that viability is a good line.
Well, it's focused on the idea of fetal separateness, and I think that that is a line that also accords with the history and tradition in this country of abortion regulation. Contrary to the state's arguments here, at the time of the founding and for most of early American history, women had an ability to access abortion in the early stages of pregnancy, and it was only when the fetus was deemed sufficiently separate the states could act to bar that. So I think that the viability line also aligns with history and tradition in that respect.
Justice Thomas?
You heard my question to counsel earlier about the woman who was convicted of criminal child neglect. What would be your reaction to that as far as her liberty, and whether or not the liberty interest that we're talking about extends to her?
Well, Justice Thomas, I have to confess that I haven't read the specific case you're referring to, but if I understand the question you were posing, it sounds as though the state is seeking to regulate for a child that's been born that was injured while it was inside the womb. And I think that we are not denying that a state has an interest there. We're not denying that a state has an interest here either. Roe recognized that states have interests that exist from the outset of pregnancy. But with respect to this specific right to abortion, there are also profound liberty interests of the woman on the other side of the scale, and not being forced to continue with a pregnancy, not being forced to endure childbirth, and to have a child out in the world. And the state's arguments here seem to ask this court to look only at its interests and to ignore entirely those incredibly weighty interests of the woman on the other side.
Thank you.
Justice Breyer? Justice Lee? No? Justice Gorsuch, anything further?
I just want to make sure I understand your response to the Chief Justice. If this court were to reject the viability line, do you see any other intelligible principle that the court could choose?
Well, I think that it would be critically important, even if this court were to reject the viability line, to reinforce and reaffirm the fundamental and profound liberty interest at stake here. And
I'm sorry for interrupting, but that wasn't my question. I understand that point fully by the end of this argument. That is deeply clear to me. I understand your position. I'm just asking a question about whether you think there would be another alternative line that the government would propose or not. You emphasize that if 15 weeks were approved, then we'd have cases about 12 and 10 and 8 and 6. And so my question is there a line in there that the government believes would be principled or not?
I don't think there's any line that could be more principled than viability. I think the factors the court would have to think about are what is most consistent with precedent, what would be clear and workable, and what would preserve the essential components of the liberty interest. And viability checks all of those boxes and has the advantage as well as being a rule of law for 50 years.
Thank you. That's helpful, counsel. Appreciate it.
Justice Kavanaugh?
You make a very forceful argument and identify critically important interests that are at stake in this issue. No doubt about that. The other side says, though, that there are two interests at stake, that there's also the interest in fetal life at stake as well. And in your brief, you say that the existing framework accommodates, that's your word, both the interest of the pregnant woman and the interest of the fetus. And the problem, I think the other side would say, and the reason this issue is hard is that you can't accommodate both interests. You have to pick. That's the fundamental problem. And one interest has to prevail over the other at any given point in time. And that's why this is so challenging, I think. And the question then becomes, what does the Constitution say about that? And I just want to get your reaction to what the other side's theme is, and I've mentioned it in my prior questions. When you have those two interests at stake, and both are important, as you acknowledge, why not? Why should this court be the arbiter rather than Congress, the state legislatures, state Supreme Courts, the people being able to resolve this? And there'll be different answers in Mississippi and New York, different answers in Alabama than California, because there are two different interests at stake, and the people in those states might value those interests somewhat differently. Why is that not the right answer?
Justice Kavanaugh, it's not the right answer because the court correctly recognized that this is a fundamental right of women. And The nature of fundamental rights is that it's not left up to state legislatures to decide whether to honor them or not. And it's true, different rules would prevail throughout the country if this court were to overrule Roe and Casey. But what that would mean is that women in those states who are refusing to honor their rights and who are forcing them to continue to use their bodies to sustain a pregnancy and then to bring a child into the world will have no recourse other than to travel if they're able to afford it, or to attempt abortion outside the confines of the medical system, or to have a child, even though that was not the best choice for them and their family.
Thank you.
Justice Barrett?
I have a follow-up to Justice Kagan's question about reliance. I'm just trying to nail down, and I asked Ms. Rickleman this question too, but I'm not sure that I fully understand the government's position or Ms. Rickleman's position. So on pages 18 and 19 of your brief, you talk about reliance interests, and you quote some of the language from Casey about a woman's ability to participate in the social and economic life of the nation. And I mentioned the safe haven laws to Ms. Rickleman, and it seems to me I fully understand the reliance interests. They're the airy ones Justice Kagan was referring to, and then they're the more specific ones about a woman's access to abortion as a backup form of birth control in the event that contraception fails, so that she need not bear the burdens of pregnancy. But what do you have to say to petitioner's argument that those reliance interests do not include the reliance interests of parenting and bringing a child into the world when maybe that's not the best thing for her family or her career?
I think the state is wrong about that. And I think where the analysis goes wrong in reliance on those safe haven laws is overlooking the consequences of forcing a woman upon her the choice of having to decide whether to give a child up for adoption. That itself is its own monumental decision for her. And so I think that there's nothing new about the safe haven laws, or at least nothing new about the availability of adoption as an alternative. Roe and Casey already took account of that fact. And I think that there are certainly, of course, all of the bodily integrity interests that we've referred to, but also the autonomy interests retain in force as well.
Okay, so it's the reliance interests in the right to be able to choose to terminate the pregnancy rather than having to terminate the parental rights.
I think that that is part of it, yes. And I think for many women, that is an incredibly difficult choice, but it's one that this court for 50 years has recognized must be left up to them based on their beliefs and their conscience and their determination about what is best for the course of their lives.
Thank you, General.
Thank you, General. Rebuttal, General Stewart.
Thank you, Mr. Chief Justice. I'd like to do my best to make 3 points. First, picking up where you just left off, Justice Barrett, on safe haven laws. The respondents in this case, I believe, as Your Honor pointed out, have emphasized parenting burdens being a lead or the lead reason that women seek abortions. I would emphasize safe haven laws, as best I've been able to find, first came into existence in 1999 in Texas. They're now ubiquitous, and you're correct, Justice Barrett, that they relieve that huge burden. I would also add that as to burdens during pregnancy, I would emphasize that contraception is more accessible and affordable and available than it was at the time of Roe or Casey. It serves the same goal of allowing women to decide if, when, and how many children to have. And I would also note, just frankly, the lowest cost abortion at Jackson Women's Health is $600 for the abortion. Additional costs and further fees. According to my friends, the respondents and their amici, there are also additional costs related to travel, taking off time off of work, accommodations, all of those sorts of things. Whether somebody is uninsured or not, the costs of contraception are consistently significantly less than those. Number two, I think Justice Kavanaugh, you had it exactly right when you use the term scrupulously neutral. I think that's a very good description of what we're asking for here. I think it's the problem and the value that has evaded the court and will continue to evade this court under Roe and Casey, but that is exactly right. This is a hard issue. It involves, and I would emphasize, Your Honor, that as you said, there are interests here on both sides. There are interests for everyone involved. This is unique for the woman. It's unique for the unborn child too, whose life is at stake in all of these decisions. It's unique for us as a society in how we decide, if the states get to legislate on this issue, how to decide and how to weigh these tremendously momentous issues. In closing, I would say that in his dissent in Plessy versus Ferguson, Justice Harlan emphasized that there is no caste system here. The humblest in our country is the peer of the most powerful. Our Constitution neither knows nor tolerates distinctions on the basis of race. It took 58 years for this court to recognize the truth of those realities in a decision, and that was the greatest decision that this court ever reached. We're running on 50 years of Roe. It is an egregiously wrong decision that has inflicted tremendous damage on our country and will continue to do so and take innumerable human lives unless and until this court overrules it. We ask the court to do so in this case and uphold the state's law. Thank you, Your Honor.
Thank you, General. Counsel, the case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
All right. Well, what we just heard was some very impactful arguments from the Mississippi solicitor, from the attorney for Jackson Women's Health Clinic, and from the U.S. Solicitor General. That we've recently we really it's about 6 minutes long, so let's go ahead and roll that. I'm here to tell you that the current pro-life strategy to end abortion is not working. And I'm going to tell you what we need to do instead. Hi, I'm Bradley Pierce, attorney and executive director of the Foundation to Abolish Abortion. In the U.S., we hear a lot about Roe v. Wade, the 1973 Supreme Court decision that claimed to establish a right to abortion in America. Those of us against abortion have been trying to get the Supreme Court to overturn this evil decision for the last 5 decades. And how have we gone about doing that? Well, from the beginning, the primary pro-life strategy has been straightforward. Change the court. To do that, you first elect Republican presidents, then when they take office, you wait for a vacancy, then you appoint pro-life justices, and once there's a majority of pro-life justices, you overturn Roe v. Wade. Simple as that. But how has this plan worked? The answer should be obvious. It hasn't. Roe has not been overturned, and more than 2,300 preborn children are killed in this country every single day. Despite 5 decades of failure, changing the court is still the carrot on a stick that Republican candidates use to get votes and rake in political donations. Every presidential election, pro-life voters are told, if we could just get a Republican-appointed majority on the Supreme Court, Roe v. Wade would be overturned. But making this our primary strategy has been a failure from the beginning. In fact, the Supreme Court, which decided Roe v. Wade in 1973, was made up mostly of justices appointed by Republican presidents. That's right, you heard that correctly. Roe v. Wade was issued by a court with a majority of Republican-appointed justices. Then in 1992, the Supreme Court upheld Roe by reaffirming a right to abortion in the Planned Parenthood v. Casey decision. But that court was made up of Democrat-appointed justices, right? Wrong. In fact, of the 9 justices on the court in 1992, 8 of them had been appointed by Republican presidents. And amazingly, the only Democrat appointee on the court was pro-life and had voted against Roe v. Wade. Not only that, Since 1973, the court has never had a Democrat-appointed majority. Of the 15 justices appointed since Roe, Republican presidents appointed 11 of them. Do you find that shocking? Roe was established and has been kept in place by a Supreme Court which has been overwhelmingly dominated by justices appointed by Republican presidents. To put it bluntly, ending abortion through changing the court has been a false hope since the very beginning. Even today, the makeup of the court is yet again exactly what the pro-life industry has been telling us would be needed to overturn Roe, but still nothing. Today, there is only one sitting justice who has ever publicly indicated he would vote to overturn Roe v. Wade, Justice Clarence Thomas. And every time Justice Thomas publicly asks his fellow justices to agree with him on that, all we hear is silence. So what should we be doing? First, understand that Roe v. Wade is not the law of the land. Have you ever seen anything about a right to abortion in the Constitution? Of course not. Even the Supreme Court has admitted that it's not in the text, but claims it is in a right to privacy, which is in the penumbra of the Constitution. What is that? Well, when you shine a light on an object, the shadow behind it is called an umbra, and the fuzzy shadow outside of that is called a penumbra. Of course, that's just a really twisted way of saying it's not in there. In fact, the Constitution says the opposite and defends all human life, preborn or otherwise, in the 14th Amendment by saying that no state shall deny to any person within its jurisdiction the equal protection of the laws. If you really want to follow the Constitution, you also must follow the Supremacy Clause. The Supremacy Clause says that this Constitution and the laws made in pursuance thereof shall be the supreme law of the land. So anything the Supreme Court says is only binding on the states if it's consistent with the Constitution. That's why our officials swear an oath to a Constitution and not to a president or to a court. So the states have a duty to ignore unconstitutional federal edicts like Roe v. Wade. So what do you want to do? Do you want to stick with the existing pro-life strategy, waiting till we get a Republican president, waiting for a justice to die or retire, waiting to win the court with another Republican nominee, even though that's been a failing strategy for nearly 50 years? Are you really ready to wait another 50 years while thousands more die every day? I'm not. If we want the Supreme Court to start treating Roe v. Wade as unconstitutional, then we must do so. Roe v. Wade is not the law of the land. We need to say that. But much more importantly, we need to start acting like it. We need to follow what the Supremacy Clause of the Constitution says and call on our politicians to pass legislation to end abortion without compromise and without waiting for the Supreme Court. The time for us to abolish abortion is right now. It's time to ignore Roe. All right, like we talked about there, we need to ignore Roe, right? And that's what we're here today. That's why we're here today, because it's not just the duty for Roe, although it certainly is duty, but it's court to ignore Roe. A community has been saying for decades the Supreme Court should overturn Roe versus Wade. That's essentially, that means that we should ignore Roe, right? We should override Roe. It's not the law of the land. Let's stop treating it like it's the law of the land. So that's what we should do. And that's what the mission of Abolish Abortion Texas. That's one of our big principles and the foundation to abolish abortion. All right. I'm going to be coming back to that because I'm going to be talking about the brief that we've submitted to the U.S. Supreme Court that they have under consideration. They're taking the oral arguments that you heard today under consideration. They're going to be taking under consideration the briefs that have all been filed by the parties and also the numerous amicus briefs filed by friends of the court like to abolish abortion and Abolish Abortion Texas. All right, so I want to go through the oral arguments of the court that we just heard today from the Solicitor General from Mississippi, from the attorney for Jackson Women's Health, and from the United States Solicitor General from the Biden administration. And I hope you can hear me. I've got a lot of noise behind me, but hopefully you can hear me. If not, I think my tech guys are going to tell me, and I can switch to a different kind of microphone mode. But let's just keep going right now. So the Mississippi Solicitor General started out oral arguments. And like I said, the first 2 minutes of his arguments are without any interruption. After that, the justices on the court have an opportunity to interrupt and start asking questions, generally in the order of their seniority on the court, starting with Chief Justice and then from the justice who's been on the court the longest. And then near the end, they then have each justice go through one at a time, again, in order of seniority. So that's what we heard, starting with the Mississippi Solicitor General. So let's talk about what he said, and even more importantly, what the justices on the court asked about and what that may indicate. So I want to ask you right now, right before I get into that, if you have not already signed the brief supporting abolishing abortion, please click the link now in the description or in the post if you're on Facebook with this, or go to abolishabortiontx.org/sign-the-brief and add your name to the brief so that your name can get in front of the Supreme Court supporting our brief, supporting abolishing. So please do that now. All right, let's talk about the Mississippi Solicitor General's arguments that he made. First of all, he made it very clear that he's arguing for the overruling of Roe versus Wade and Planned Parenthood versus Casey. And just a quick recap: Roe versus Wade, 1973, did the so-called woman's right to an abortion. It did. Any kind of law so that was 1992. Justice and Republican presidents. And that her holdings of Roe and so they're there to argue over Roe versus Wade and Casey. Integrity, and I'm sorry, I'm getting a message.
We're on standby.
lots of people out with their cell phones are using a lot of signal. It includes us. So we're trying to make sure use the best. We a little further down. We haven't here. That of Mississippi, very clearly. Of versus Wade, so-called right to an abortion, and then added a standard that cannot create. All right. I think we are back live here. We're going to try for a little bit, just doing me on audio and turning off the video. Because like I said, there's a lot of people out here using a lot of signal, and we're one of them. So we're going to see how this works. So please bear with us here. But just imagine the Supreme Court behind us here. But what is on the screen right now is a reminder to go sign the brief and add your name to the brief supporting the abolishing of abortion. All right, let's get back into the arguments. So the Solicitor General argued that most importantly, Roe versus Wade, Planned Parenthood versus Casey, were not found in the text of not grounded in the text was the term that he used of the Constitution, which is absolutely right. There's as we've pointed out before, both sides agree that there's nothing in the text of the Constitution that provides for a right to an abortion. It's something that was created, by trying to read between We're till we get this. Here. Tethered to your phone. Let's try that. All right. Well, we're having lots of issues here. Like I said, signals are not very great here. But we're working. And we just ask you pray for us so we'd have a good signal. Or if we don't, hey, we know that's God's will. We do have a bad signal again. We are going to take a break and play a video for you that I recently about why that we must ignore Roe. So that's going to be playing if we need to move into a location with some good Wi-Fi, so we can make sure that we take care of this problem. But right, I'm going to go ahead and keep going unless they tell me that there's a problem. So we were talking about the Mississippi Solicitor General giving his arguments. The one thing that was interesting while he was giving his arguments, Justice Breyer, one of the most senior members of the court, he was talking about Roe versus Wade, and he said that there was a lot of contention in the country, a lot of division about the issue of abortion, and so, and as he put it, the country decided to lay down its differences and have this court decide this issue. Which I thought was just astounding. That's a complete revisionist history about how we got Roe versus Wade, is that the country somehow decided to, well, we can't resolve our differences, so let's give it to the court to decide it for us. I don't think that's at all what happened. I think that's revisionist history. And I think instead the court grabbed the authority and took it away from the states and the people. We live in a country that's supposed to be the consent of the governed, right? And to follow the Constitution. And the Supreme Court in Roe versus Wade did not do those things, and in fact took away the consent of the governed. So one thing that we also, I think that's very telling that we're going to hear, or that you heard throughout the arguments in the Supreme Court, is that there's a very the Supreme Court is very sensitive about their perception, how people perceive them as an institution, and whether that's going to, the institution of the court seem to be on the forefront of a lot of the justices' mind, especially Chief Justice Roberts, we heard, but even Justice Breyer, we heard him say that we should not yield to political pressure. Right, he wanted to make it clear that we want to make that the court wants to make it clear that they're not yielding to political pressure, right? Because the court is supposed to be perceived, at least, as an independent institution that decides on the law and not on the facts. That decides on the law using reason and not emotion. That decides on the basis of reason and not politics. That's the way the court likes to be perceived. Of course, those of us who paid attention to it for a really long time know that that's not always the case. It is a lot of the times, but not always. And Roe versus Wade is certainly one of the worst examples of the court ignoring the law, ignoring the Constitution, and ruling on the basis of emotion, on the basis of politics, however it wanted, and completely ignoring the text of the Constitution. Breyer said, hey, Planned Parenthood versus Casey, yeah, it's done some bad things. But it's done some good things. Yeah, no, I don't see how any good thing can outweigh the 62 million children a year that have been slaughtered under Roe versus Wade and Planned Parenthood versus Casey. Let me stop real fast and just encourage you, if you haven't already, sign the brief. The link is in the description, abolishAbortionTX.org. Sign the brief. All right, I'm going to keep going. Justice Sotomayor, one of the appointees from President Obama, she pointed out, interestingly, that of the last 19 justices on the court since Roe versus Wade, 15 of them have upheld Roe. And that's a very interesting observation. It's also interesting that of the 19 justices appointed to the court, 15 of them were appointed by Republican presidents. So of those 19, 15 of them upheld Roe versus Wade, but it was that was mostly Republican appointed justices. That's why we at Abolish Abortion Texas Foundation to Abolish Abortion are constantly saying, stop holding your breath for the Supreme Court to do what's right. We have to do what's right, regardless of what they do. They should do what's right. They should overturn Roe. But even if they don't, we need to do what's right and abolish abortion in our states now. Again, continuing on the theme that of the institution of the court and the public respect of the institution of the court, Justice Sotomayor asked the question of the Mississippi Solicitor General: can this institution survive the stench it would create to appear as a political institution? And I just want to give a quick disclaimer: these quotes are as I'm scribbling them down, so they may not be, exactly right. So my apologies for that, but I think that's close to what she said. Can this institution survive the stench it would create to appear as a political institution? Well, the horse is already out of the barn, as we say in Texas, on that front, because the court did that 49 years ago. Versus Wade. What it needs to do to survive is the stench over return obey. Which was kind of interesting. A number of Second Amendment cases coming before the court this term. The Justice Howard kind of threw some shade on a small fringe of doctors that believe that there's a fetal pain before a cortex is formed, talking about fetal pain and things like that. And the reason they're talking about that is because in a lot of states they passed 20-week bans, so-called fetal pain abortion bans. And that's not really what the issue is. And that's one of the reasons we should be passing these, because it's a red herring. It's not an issue. The pain is not the issue. The issue is the life. The issue is homicide, not whether or not the person can feel pain or not. There's lots of people who can't feel pain that we still shouldn't murder, right? So the issue is not pain. The issue is homicide. That's why we need to provide equal protection. We need to be protecting preborn children with the same laws that protect born people like you and me, because they're equally valuable, equally made in the image of God. They're deserving of equal protection. And in fact, the Constitution requires equal protection, as does God's law. Chief Justice, he had a number for the attorneys in this case that I think were kind of and at the same time, we're also very telling about where he is. We've kind of speculated before that what's the court going to do in the future? We're not prophets. But, if we were to speculate what we think the court may do, my speculation as an attorney is that, there's lots of options that the court could choose. But one of them is to uphold the 15-week ban, but to somehow also uphold Roe versus Wade, Planned Parenthood versus Casey, and a so-called untest. In other words, to just move the line. Right now, the line is at viability. Prior to that, the court has said the states have no, that they don't have any compelling state interest and that overrides a woman's so-called right to an abortion in regulating abortion. But after viability, they do have some. So that's why you've seen a lot of challenges upheld, like 20-week bans and things like that, because they're very close to viability, because many of those are actually 22-week bans from fertilization. So the issue is what we heard from Chief Justice Roberts is over and over and over again him talking about, well, what about moving the line, right? The line is viability. What about moving the line? He even thinks he asked the Mississippi Solicitor General about, well, was viability ever even raised in Roe? And it really wasn't by the parties. It was something that as Justice Blackmun, the author of the Roe opinion, later said, was dicta. That means it's something that the court came up with that was not an actual holding of the court. That was just them dicta. That is just speaking on something without actually ruling on it. So I think Chief Justice Roberts, it sounds like he's wanting to just move the line, right? Move it maybe from 20 weeks down to 15 weeks, but still allow women to have abortions prior to 15 weeks. Unfortunately, that's what that's my read on where Chief Justice Roberts is right now. As I mentioned earlier, Justice Sotomayor, she admitted that Roe is not in the Constitution, but it is discerned from the Constitution. Right? In other words, you have to read between the lines, or as the court put it many, many years ago, before Roe versus Wade, and then citing it in Roe versus Wade, citing Griswold versus Connecticut, that there's this right to privacy in the penumbra of the Constitution, which is a penumbra is just a shadow of a shadow, which means it's not in there. So, like Justice Sotomayor herself admitted, it's not in the Constitution, but as she said, it's discerned from the Constitution, which is, again, just another way of saying it's not in the Constitution. So we see Justice Sotomayor tries to make it all about religion, which is in some ways a red herring, but in other ways is insightful, because we believe as Christians that there is there's no neutrality, that you're either for Christ or you're against him, and there's good and there's evil, right? There's right and there's wrong, and we believe that all issues are ultimately religious. You will either serve God, the Creator, or you serve man or the creation. And so, yes, in some sense, in the most important sense, everything is religious. But she tried to make it that isn't it a religious issue about when life begins? And certainly, it is that, but it's also a very clear scientific issue. She's asking the Solicitor General of Mississippi when life begins, who points out that even in one of the Supreme Court's cases itself, Gonzalez, upholding a partial birth abortion ban, that the court held or said that from moment of fertilization, basically, it's a human organism. Well, we believe that at the moment that a human begins, that's when a person begins. So, yes, they're a human from the moment of conception, worthy of equal protection from them. Justice Sotomayor pointed out, and I'm not vouching for the accuracy of this, but she claimed that it was 14 times riskier to carry a baby to full term than to get an abortion procedure and terminate, that is, to kill one's own child. I don't really know whether that's accurate or not. And this is another reason why it's ultimately, that's not what the issue is about. The issue isn't about, weighing, practical arguments and pragmatic arguments. The issue is really about life. The issue is about murder. The issue is about homicide. It's not about weighing risks, right? Once a baby has been produced, has been reproduced, at that point, it's not an issue. It's not a question of anything except for the government's duty to protect that life, and that is a God-given duty. So that's why we don't need, what's important is not the risks and benefits and things like that. We're talking about human lives. This is not a time to be talking about risks and benefits. Again, just moving on to Justice Kagan, Elena Kagan, she said, we don't want the public, she basically said, we don't want the public to think the court is a political institution that goes with whichever side yells the loudest, as she put it. Again, as we can see there, the court has is very sensitive about how it's perceived, and that it's not perceived as a political institution. Again, the perception of the court is important, and public respect for the court is important. What's most important is doing what's right, regardless of the perception. It's what's doing what's right on the case before them, and protecting human life, regardless of the perception. And also, the court is going to be perceived as political, regardless, because it made itself look political when it stepped in and ruled in Roe versus Wade, and made this a political issue more than ever before, and made itself the arbiter of that political issue. So to at this point say, well, we don't want to be political, again, it's a little too late to put the toothpaste back in the tube. Or is it? Because there is a way to do it, and that is to overturn Roe versus Wade. It's not going to be perfect. It's not going to be perfect. It's still going to be disruptive, but it's far less disruptive than the damage that's been done to the rule of law in this country over the last 49 years, and most importantly, the lives that have been lost during that time. So this is just, and again, another reminder that we need a standard, and the standard has to be God's law. And in this country, the highest law of the land is the Constitution. So that's also our standard. She pointed out there's been 50 years of water under the bridge that places us in a different situation than if you had come in with these arguments 50 years ago. Again, ultimately, does it matter how much time there's been? Does it matter? Either the Constitution supports this or it doesn't. Either it's right or it's wrong, and time has not changed that. The Solicitor General of Mississippi pointed out that there's been termination of millions of lives at this point. That the court should return it to the people to work through and to find solutions. Again, Chief Justice Roberts chimed in, going back to the viability issue, again, sounding like he's interested in just moving the line from viability to 15 weeks, something like that. That's what it sounds very likely from the Chief Justices. At least that's my speculation as an attorney. And then arguing that the court should, Solicitor General pointed out that they had argued that the court should at least get rid of the viability line. Well, oftentimes when you argue for the court to do the least, that's oftentimes what they do. Thankfully, they are also arguing for the complete overturning of Roe versus Wade, but a lot of times the court is going to do as little as possible. So that may be what happens here, that they just move the line from viability to 15 weeks, and given both sides enough to claim some kind of a victory. That's possible. We've been seeing that sort of thing for the last 49 years on this issue, and so I wouldn't be surprised if we continue to see that. I'm going to keep going with more analysis here. There's a lot more to say, but I'm going to take a quick moment just to remind you, if you haven't already signed the brief, sign the amicus brief, friend of the court brief that we have filed with the United States Supreme Court, that we filed, the Foundation to Abolish Abortion, myself as an attorney, supported by 20 other organizations and 20 state legislators who have signed on to that, supporting that. That brief says that it's also supported by numerous other Americans. And there's a link in that brief for the Supreme Court to go see the names of those Americans who support that, who support abolishing abortion. And if you want them to see your name, sign the brief. Sign the brief. We'll be displaying your name on the Foundation to Abolish Abortion website. The link to that is in the brief for the Supreme Court to go and see your name. We will not be including your email or your zip code if you're worried about that. All right. Then coming back to analysis of what happened there. So Justice Kagan, she was wondering what happens if we remove the viability line and we keep the undue burden. What would that look like as an intermediate solution? Again, we're seeing some hints that may be where the court is headed. Is okay, let's find some kind of something to make everybody not happy, but at least to calm down a little bit. Let's kind of find some kind of compromise here. And so what happens if we just move the line? She may not be indicating that she would be supportive of that. In fact, she may be asking the question to get some ammunition against that. But it certainly sounds like that's a conversation that's happening in the courthouse that she's at least, plugged into. The Solicitor General of Mississippi said that there is no good solution to intermediate. You really need to go all the way. And that's true. You need to overturn Roe versus Wade. You need to go all the way and overturn Roe and overturn Planned Parenthood versus Casey. That doesn't mean that's what the court's going to do, but that's what we hope for. Justice Kavanaugh, again, this is something very troubling, and I think both from a principal perspective and from a strategic perspective, Justice Kavanaugh weighed in 2 or 3 times and asked the attorneys for the parties. He specifically asked the Solicitor General of Mississippi, "You're not arguing that the court should not order the states, right?" Solicitor General said yes. Again, what he's saying there is, you're not saying that the court should order the states to prohibit abortion, are you? And the Solicitor General said, no, we're not. We're not arguing that. Well, that's a big problem. And let me explain a little bit more. In fact, Kavanaugh went on and said, Justice Kavanaugh said, the Constitution is neutral on the issue of abortion. essentially neutral on the issue of abortion, and that the court should essentially be neutral on the issue of abortion by returning it to the states, and that the Constitution is neutral on the issue of abortion. And Solicitor General affirmed, yes, that's what they were arguing. Unfortunately, in making that kind of an argument, you're totally jettisoning and waiving the argument of what we call equal protection. The 14th Amendment of the U.S. Constitution says that no state shall deny to any person within its jurisdiction the equal protection of the laws. That's what the Constitution says. So we argue that a fetus is a person, right? And either a fetus is a person and is deserving of equal protection, or a fetus is not a person. And the entire pro-life movement, which has been saying a fetus is a person, is wrong. Well, the pro-life movement has been saying a fetus is a person, but now here we have the Solicitor General of Mississippi arguing the biggest pro-life case in, maybe in history, and he completely waives the argument that a fetus is a person deserving of equal protection. That's not just a small thing. That is a big thing, to completely waive that argument, say that's not what we're arguing. We're not saying the state should be required to provide equal protection. We're just saying that it should be, given back to the states for them to make up their own minds. That's a big argument to waive. But that's exactly what he did at that point and later on. So he just completely jettisoned the 14th Amendment argument, which says that no state shall deny to any person within its jurisdiction the equal protection of the laws. So if you believe a fetus is a person, then they're deserving of equal protection of the laws, right? That seems pretty simple. What does equal protection of the laws mean? It means that the laws that protect you and me as born people should be the same laws that protect people before they're born. That's a pretty simple concept, because a fetus is equally made in the image of God. A fetus is equally a person. They're equally human. They're equally valuable, equally priceless, right? So they should be equally protected by our laws. And that's what the Constitution requires. And our governing authorities need to submit to the our officials, like the court and others, need to submit to the governing authority, the highest law of the land, man's law of the land, the U.S. Constitution, and provide equal protection. But in this case, the Mississippi Attorney General completely waived that argument. So that was very concerning. That was very concerning to see that. Just strategically, you're just giving up a really good argument. Maybe you can argue in the alternative that the 14th Amendment requires states to provide equal protection, but court, even if you don't agree, then it should also be returned to the state. But he didn't even do that. He just completely waived a very strong argument. So that was really concerning. And it's one thing that we cover in our brief that we submitted to the U.S. Supreme Court right here by these organizations, 20 state legislators, and as you see here, numerous other Americans for abolishing abortion. So if you want your name on that brief, if you agree that a person before birth is entitled to equal protection as someone after birth, then please sign our brief. Because if you believe that, like we do, that wasn't represented in what was argued here today by the Solicitor General of Mississippi. He did a fine job on a number of points, but that one, he completely waived that argument. That was very concerning. So if you believe that a child is equally made in the image of God from the moment of fertilization, from the moment of conception, then please go sign our brief. The link is in the description, or go to abolishabortiontx.org/sign the brief. All right, getting back to analysis here. Again, Justice Barrett, even at the end of the petitioner Mississippi's initial oral arguments, even she started talking about the court's legitimacy. And the Solicitor General even talked about the court's legitimacy and about looking out. In other words, the court generally is looking in to the Constitution, is not worried about what happens outside the courthouse, the political pressure and things like that. But even the issue of looking out was brought up, that that's an issue that's important to the court. And that's an issue that we discuss in our brief, that the public respect of the court is important. That's an issue we know is important to the court, and it should be important to the court. But it's not more important than the text of the Constitution. It's not more important than God's law. And so, yeah, it's worthy of consideration. But you know what's going to renew public respect the most? Standing on the foundations that you're built on. right? What created the U.S. Supreme Court? The Constitution, by we the people through the states. That's what created the U.S. Supreme Court. So every time the U.S. Supreme Court ignores the Constitution, it's undermining the foundations of its own authority. And that can't stand. That can't stand forever. So that's why what it needs to do to continue its own, to support its own legitimacy, to support the public respect that it desires to have, is to reinforce its foundations, to reinforce its Constitution, and most of all, to repent before God. Because inviting the judgment of God is what we've been doing for 49 years, and that's not good for the Supreme Court or for our entire country. So we need to get on our faces before God and repent and follow the rule of law. All right, after the Mississippi Solicitor General was up there, then we have Jackson Women's Health attorney, Center for Reproductive Rights, that their attorney was representing Jackson Women's Health, the abortion clinic, the only surgical abortion clinic in the state of Mississippi, as far as I'm aware. She argued a number of things. She kind of started off arguing the rule of law. The rule of law, which is a phrase that we use all the time, right? But the issue with Roe versus Wade and Planned Parenthood versus Casey is that they're not the rule of law. They're the rule of man, right? We have a principle in this country that we are a government of laws and not of men. In the UK, the parliament there still swears an oath to the Queen or the King as applicable. But in this country, we don't swear an oath to a person. We don't swear an oath to an institution. We swear an oath to a document. Our legislators do, and even I, as an attorney, have done, is we swear an oath to uphold a document because we're a government of laws and not of men. We're a government we're a government of laws and not of institutions. So we follow the law, not the institution. That's what the highest law of the land. That's the true rule of law. And when men violate the higher law, that's called tyranny. And that's what the Supreme Court's been engaged in for the last, next month, 49 years, is really judicial tyranny on this issue and lots of others. But lots of the other ones have flowed out of our complete abdication as states to stand up to the tyranny by doing what we call ignore Roe. And that is not to disregard the Supreme Court as an institution. It's a good institution. It's created by the Constitution. It's ordained by God like all governing authorities are. But it has limits. There are limits to its jurisdiction. We're not to give it unlimited submission. Otherwise, if we do so, we've just made it into God. We just treated it like God. And in fact, when we do so, we disobey God. We disobey God when we do that. So we need to stop doing that. So then Justice Thomas, we heard him when the Jackson Women's Health was arguing their case. Him talking about and really just pointing out the inconsistency between saying that, hey, a mother who's pregnant who does cocaine, she can be criminally charged with reckless child neglect, but that same mother can go get an abortion. How does that make any sense? That's not the way that he put it, but I think that was the point that he was making. And I think it's a very good one. It doesn't make a lot of sense. All right, there's a group over here getting ready. This is exciting out here. There's a lot of excitement going on. A lot of people out here arguing for life and arguing for death, really, because arguing for the ability to get an abortion is an argument for death. If you agree with that, if you want to abolish abortion, please go sign our brief, abolishAbortionTX.org/sign the brief, link in the description here. All right. This was interesting. Justice Breyer, who is an appointee of President Clinton, he points out, why is 15 weeks not enough time? Again, getting to the issue of the line, right? The line right now is currently viability as far as when the states have an interest in regulating that may override a woman's so-called right to choose. They're wanting to move. There's some justices that are talking about moving the line. There's a lot of them talking about that. I feel more strongly than I did before that may be where the court is headed in moving the line from 20-ish weeks to 15 weeks. So even Breyer, one of the Democrat appointees, was asking about that. Again, not that he necessarily supports it, but it's an issue that everyone's talking about quite a bit. Let's see here. Other issues. Again, Chief Justice Roberts again talks about moving the line. What about undue burden? Why can't we move it to, get rid of viability and make the line undue burden? Maybe not 15 weeks, but make it undue burden. And that could effectively be 15 weeks. The Jackson Women's Health attorney said, no, undue burden test is not an issue. This is about viability. And in some sense, that's true, but the court could, and it would not be outside of its history of creativity to reinvent the undue burden and to make it extend even to bans between 15 and 20 weeks to allow for those. That's certainly something that I could see happen. If the court steps past viability to an undue burden standard, would that be workable? Was what Chief Justice Roberts was asking the attorney for Jackson Women's Health. Something that he's obviously seriously considering. Would it be workable to move the line from viability to undue burden? Again, they pointed out that the viability line is the central holding of Roe, and that you would essentially be overturning Roe at that point. Not necessarily. There's still the so-called right to an abortion that is in Roe, so it would not require a complete overturning of Roe to move that line. So I could see the court doing that. I could see the court moving the line from basically 20 weeks to 15 weeks and still upholding Roe, further entrenching it in our country's jurisprudence and further inviting the judgment of God. So, again, this is why it's so important that regardless of what this court does, right, regardless of what they do here in the next, between now and June or July when we're expected to hear back from them, their opinion in this case, regardless of what they do, it's important for people to be working across the country in their states to do what's right, regardless of whether the Supreme Court does what's right. And that's one of the things that we argue in our brief, is that regardless of whether the Supreme Court does the right thing or not, the states should do it. As we put it, and you're welcome. I hope that you can go read this. Actually, you can get a link to this brief if you go to abolishfortuntx.org/sign the brief. At the bottom of the page, there's a link to this so that you can download it. You can see it on our webpage, or at the bottom of that page, there's a link. You can go even read it on the Supreme Court's website. And we said one of our first major point, of course, is that the court should overturn Roe versus Wade. And our first point was Roe versus Wade and refusal to overrule it undermines the legitimacy of the authority of the court, which was a big topic of conversation today. Number two, we said where the court does not restrain its authority within its legitimate bounds, the court impels those faithful to the Constitution to seek redress via other constitutional avenues. What are those avenues? Well, you can certainly amend the federal Constitution, but we point out that's not a really good solution. You could also have other remedies, federal level remedies, and then state level remedies. The state level remedies are what we call ignore Roe. And then finally, we point out that, yes, it could be disruptive to doing that. Admittedly, these constitutionally available remedies are more disruptive than the court overruling Roe itself, which is what we want. But the states standing up and ignoring Roe and abolishing abortion in their states are not as disruptive as allowing continuous mass prenatal genocide or the continual undermining of the rule of law. And that's what we've had for the last 49 years. So, yeah, if the court overturns Roe versus Wade, that's going to be disruptive to society. If the court doesn't, that's going to be disruptive because every day that Roe versus Wade is allowed to stand, we're undermining the rule of law, and over 2,300 children are killed every day. Just that's reported. That doesn't even include those that are killed by various other kinds of abortifacients that are never reported. So that's important. That's important that regardless of what the Supreme Court does here, that the states, that we keep pushing in the states to exercise their constitutional authority, because the supremacy clause of the Constitution says this Constitution and the laws which shall be made in pursuance thereof shall be the supreme law of the land. Well, as we've heard today, Roe isn't in the Constitution. There's not a right to abortion in the Constitution. Even the Democrat-appointed justice said it's just something, it's not in the text, it's discerned from the Constitution. Well, that means it's not in there. And if it's not in there, then any decisions that say, that creates a so-called right are not made pursuant to the Constitution, so they're not binding on the states, which means we should be disregarding them because they are an act of tyranny. They're an act of tyranny. So continuing on, let's see here. Justice Kavanaugh again repeated the unfortunate, argument that he's pointing out to Jackson Women's Health attorney. He said the other side, that is Mississippi, says that the Constitution is neutral. It's neither pro-life nor pro-choice. So we should return the issue to the as an institution, that the Supreme Court should remain a neutral institution and return the issue to the states. Again, we don't believe that the Constitution is neutral on the issue of life. We don't believe that the Constitution is neutral on the issue of abortion. We believe that the Constitution requires equal protection. That's why our third of our 3 points is that in our brief is that in addition to overruling Roe, the court should recognize that the Equal Protection Clause of the 14th Amendment requires that state laws protecting born persons against homicide may not deny equal protection to persons not yet born. So, no, we don't believe that the Constitution is silent. We don't believe that at all. We believe that the Constitution is clear that the states must provide equal protection to preborn children from the moment of fertilization. By the way, equal protection is not a 15-week ban, right? We don't have a 15-year-old ban on homicide, right, where you can kill anyone who's under 15 years old, right? That wouldn't be equal protection. People older than 15 years old would get better protection than someone under 15 years old. That was not equal protection of the laws. Well, the same is true for someone who's in their mother's womb. Equal protection means that the same laws that protect you and me as born people should be the same laws that protect them as people who are not yet born. And that's what we argue for in our brief. So again, if you agree with that, I want to ask for you to put your name on that brief so we can show the Supreme Court the support of those who support abolishing abortion and providing equal protection, because we're all equally made in the image of God from the moment of conception. So if you support that, please sign the brief, link in the description, or go to abolishabortiontx.org and do that. All right. Then we also heard, after the attorney for Jackson Women's Health, we also heard from the Biden administration. They actually filed a brief in this case saying, hey, we want to come. We want to make arguments, and we want to show up and make oral arguments to the court, and the court granted that. So in addition to Mississippi and Jackson Women's Health, we also heard from the United States Solicitor General. What's a Solicitor General? Of course, Mississippi had one, and now we had one from the United States. Well, many people have heard of attorney generals, right? They're the charge with the enforcement, ultimate enforcement of the state's laws and defending of those laws. Well, a solicitor general is someone who does that in the courts. So the attorney general is kind of the head, in this case, of the Justice Department. The solicitor general works under the attorney general to then go argue in the courts. Them and their staff go argue in the courts as directed by the Attorney General. So the Attorney General of the United States is Merrick Garland, and the Solicitor General is Miss Prelogar. And so she was arguing on behalf of the Biden administration, on behalf of President Joe Biden. And she, her strongest argument that she made was stare decisis. You may have heard that term several times as the court was considering this. Stare decisis. For most people, we just call that precedent, right? That is, whatever the court has decided before, we let it stand, right? Because, we assume, we kind of presume that it was the right decision. And that unless something has dramatically changed, or we've had some dramatic revelation, that you shouldn't go back and change your decisions. How you're ruling on things. So that's basically the main argument from the Biden administration, is that under stare decisis, that is precedent, the court should not overrule Roe versus Wade or Planned Parenthood versus Casey, because, as they argued, those are precedents on precedents, right? Those are super precedents, as we've heard some other people say before. Well, again, no matter how many times something's been decided wrongly, it's always the right thing to do to decide it rightly. It's always the right thing to do to change how you're deciding things when you keep deciding things wrongly. And Chief Justice Roberts pointed that out. He was talking about Plessy v. Ferguson, which said that had said separate but equal for people of different skin colors was okay. That was egregiously wrong, and that even if nothing had changed, he was implying that couldn't that be overturned? Shouldn't that be overturned? That it was when it was egregiously wrong, even if none of the facts changed, even just a few years afterwards, shouldn't that be overturned? And the United States Solicitor General said, no, just the fact that a decision was egregiously wrong is not enough. There needs to be additional factors to overturn a precedent, especially a super precedent in this case. And that's, that's pretty concerning. That's pretty insulting that she's arguing that the case that said people of different skin colors are separate but equal, that shouldn't have been overturned then. No, she did say it should have been overturned later once you had all additional factors, but immediately after, if there's no facts changed, no, you shouldn't overturn that. Even though it was, of course, the wrong constitutional decision from the very beginning. So that was very, very interesting. Justice Kagan pointed out that people have built their lives around Roe versus Wade and Planned Parenthood versus Casey. So there's significant reliance interests on those decisions of Roe versus Wade and Planned Parenthood versus Casey, and that Casey reviewed people who have organized their lives around the right to an abortion. So they're relying on that, and unfortunately, that's true. There's some people that have built their lives and their careers around this presumption that if they get pregnant, if they have a child growing inside of them, that they can go hire someone to get that child killed or do it themselves. And that's sad. That as a country, that's where we are. And we've been that way for a long time. And you know what? On this issue and lots of others, we're seeing the judgment of God upon our country. And he's being very kind and long-suffering, but that won't last forever. And so we need to fall down on our faces and repent before God. That's what this court needs to do. And that's what we, as the citizens of this country, need to do. Fall on our faces in repentance before God and plead for him to forgive us. And if his people who are called by his name will humble ourselves and pray, seek his face, turn from our wicked ways, then he will heal our land. You know, one statistic that we heard several times in these oral arguments is that 1 out of 4 women have had an abortion. You know, this is something that I sometimes say. It's the Supreme Court isn't making anybody get an abortion, right? They're just supposedly allowing it. It's the people of this country who are going and getting our children murdered. Many of them, professing Christians. We need to repent of that. We need to repent of that before God, before we can ever hope of any healing of our country, of any blessing from God. All right, back to the analysis of the court. The analysis of God and his law and what he wants is the most important, so I want to take a break for that. And you know what? On that point, if you agree with that what God's law says is most important, then I think you're going to like our brief, and you probably want to add your name to it. Because in our brief, there's actually a section called Table of Contents, which most people have seen, but there's also a section called Table of Authorities, where you list the various authorities, cases, laws, and things like that. Well, in ours, we rank them, kind of in order that you normally do, but we kind of moved one around and moved it to the very top of the list of the Table of Authorities as the highest authority of all. I don't know if you can see it right there, but the highest authority of all is the Holy Bible, the Word of God. And that's what we said to the Supreme Court in our case and called them to rule, yes, consistently with the U.S. Constitution, but also consistently with the law of God. If you're a Christian, if you agree with that, then please go read our brief. Please sign on to it that you support it at abolishAbortionTX.org/sign the brief. Links in the description. I know I keep pushing that. You may be getting annoyed by that, but there's people who coming on and off the stream, so that's why I keep pushing it. So I hope you'll bear with me and sign the brief. Then you don't have to worry about it. All right. Like I said, there's a possibility that they could just move the line from viability to 15 weeks. the U.S. Solicitor General said she kind of implied that that could be workable, but pointed out that Mississippi is not asking for that. Neither is Jackson Women's Health. But she pointed out that that could be workable. Again, not that that's something that they're asking for, but I think it was a little bit of a tell there that the Biden administration may be able to live with that, moving it from viability to 15 weeks. I think that the problem with that is, it's going to be declared as a victory by many in the pro-life movement that, hey, we won 15, we got a 15-week ban upheld by the U.S. Supreme Court. Yay. And then we're going to see states across the country moving the line from 20 weeks to 15 weeks, passing 15-week bans. And, what have we really done at that point? We've just further entrenched Roe versus Wade in our country. And we have, we've not treated a fetus like a person. In fact, as I said, the Mississippi Solicitor General just totally jettisoned the argument that a fetus is a person. So that was sad to see. But moving it from 20 weeks to 15 weeks, that's not what we want. All right. I mean, this is a person. It doesn't matter whether they're 15 weeks or 15 seconds old. They're made in the image of God. They're biologically unique people from the moment of fertilization. And so that's why we need to protect them from that moment with equal protection. So moving from 20 week to 15 week is not the answer. In fact, it's just going to further deepen Roe in our country's fabric. Just more invite the judgment of God. Unfortunately, it's probably also going to take the wind out of a lot of the cells of people. And I think that may be what the court wants to do. I don't know. We'll see. We'll see. Like I said, I'm not a prophet. I don't know the future. Those are just some speculations that I have. So again, Justice Thomas brought up the whole argument. Hey, what about a mother who, charged with neglect for something she did to taking cocaine when she was carrying a child? Again, Alito, I think it was Alito who brought up, what about an alternative line to viability? Could there be another principled line? Again, we're seeing over and over about, hey, how about just moving the line? And this is the problem with a lot of the pro-life movement's arguments for the last 49 years has been like, hey, let's just move the line a little bit at a time. The problem is when you say let's just move the line a little bit, you are denying the humanity of the child. You are saying we should discriminate against certain children based upon their age, the method by which they're killed, things like that. You are undermining your own arguments. God's not going to bless that. And he hasn't for 49 years. And that's why we still have this in the country. And yes, reported abortion numbers may be going down. But because of abortifacients, overall abortion numbers, children dying through reported abortions and abortifacients are higher than ever. So don't let anyone fool you that abortion numbers are going down. Those are reported abortion numbers. Abortion numbers overall through abortifacients are higher than ever. The Solicitor General of Mississippi, in his rebuttal, came back and again made a very, just repeated that Justice Kavanaugh's line that the court should be scrupulously, man, I'm having a hard time with that. Okay, forget that word. Scrupulously neutral. All right, I got it that time. The court should be scrupulously neutral. There we go. I got it that time. Scrupulously neutral. Again, we don't believe that the court should be neutral. The court should be whatever the Constitution is, because it's their duty to enforce the text of the Constitution. And the Constitution says equal protection. The Constitution is not, as Justice Kavanaugh said, neither pro-life nor pro-choice. The Constitution, and again, regardless of those terms, the Constitution is not neutral. The Constitution is, we would say, abolitionist. The Constitution supports equal protection from the moment of fertilization. And so, yeah, it may not be pro-life or pro-choice, but it's not neutral. It's abolitionist. And that's why we're abolitionists, because we believe in following the rule of law, following the Constitution, providing equal protection. That's why we're abolitionists, and we call ourselves that, because the pro-life movement, making arguments like they did today, completely waiving the argument of the personhood of the fetus and the equal protection, completely waiving those. That's what got us into this in the first place in Roe versus Wade, as we argue and point out in our brief. You can read that. Go to abolishAbortionTX.org/sign the brief. There's a link to actually read the whole brief at the bottom of that. And you can see that we go through the history of Roe and even things said in the Roe. Did you know that in Roe versus Wade, the Supreme Court, the majority opinion actually pointed out, it said, because Texas was the state there, it said, they said, in arguing that a fetus is a person, Texas faces a dilemma because none of the laws of Texas treat them that way. And they said, if a fetus is a person, why is a mother not a principal or an accomplice? If a fetus is a person, why are the penalties different? Because the penalties were 2 to 5 years for an abortion, but they were, life or capital punishment for homicide. So why are the penalties different for killing someone in the womb versus outside the womb if a fetus is a person? So we waived that argument in Roe versus Wade. We're still waiving it today. That's why we're losing. So we got to stop doing that. Unfortunately, that's what Mississippi did in this case, probably on the advice of lots of pro-life organizations, legal organizations. And that's why we call ourselves abolitionists. We're different. We make different arguments based upon the Constitution, God's word, logic, and that's where we should believe we should be standing. So if you agree with us, you support abolishing abortion, sign the brief, abolishAbortionTX.org/sign the brief. All right. One last point, and then I'm going to pull in those are the end of my notes here. The Solicitor General also pointed out that Roe versus Wade has been extremely destructive, and it has. That's a good point to end on. Roe versus Wade has been extremely destructive to the fabric of our country. It's been most of all been destructive to the 62 million plus reported, we believe the number is much higher unreported, but reported abortions, and it's been destructive to our view of life, our view of children, our view of God. And that's why it's inviting the judgment of God that we're seeing in our country, along with many other issues. All right. Well, I'm so grateful to God. Thank you, God, that you have given us a clear stream here, and we've been able to continue. So I'm going to bring in one of my colleagues now, one of my fellow board members at the Foundation to Abolish Abortion, and also with Abolish Abortion Texas. His name is Wes Thomas. Some of you know him and have seen him before. Let me just slide to the side here and pull him in.
Right.
All right. I've been talking for a while, Wes. So I'm going to just hand the mic to you. Do you have any thoughts about what we heard today or
Sure.
about our brief?
Well, my first thought is that it's actually a beautiful day out here. It's been a real joy to be here. Very cold outside. There's a lot of people here. We had to move around a little bit earlier because the noise was so it was catastrophic noise is how I would describe that. It was a very difficult to hear, and but we were able to see a lot of support on a lot of pro-lifers are here, and a few abolitionists are here, and we're here to basically say, look, we don't have to, if it's a human, and if abortion is not in the Constitution, then, kind of why are we doing this? What's going on here? Why are we even arguing this before the Supreme Court? Is it in the Constitution or not? If it's not in the Constitution, well, then it's to the states. And so we're here to say, look, what we really should be doing is ignoring Roe. Not pleading for it to be overturned. And so, Bradley, I thank you for that your legal analysis. We're gonna have to go watch that again and again. That was very good. I was walking through the streets with Bradley earlier. We were both listening to the arguments as we were walking around. And it struck me. What was one of the things we heard earlier about that Mississippi was arguing? They were arguing, weren't they, that they one of the things you mentioned earlier, I think, was ignoring the basis, the 14th Amendment issues. And, that struck me as the biggest thing that they did, in my opinion, wrong, right? They totally discarded that argument, the equal protection of the laws. And, that's one of the things that we want to be strong on is the equal protection of the laws. Like every human deserves to be protected because they're made in the image of God. And that is the only basis through which humans have value and dignity. And so I was utterly disgusted that they just threw that to the ground, didn't even talk about it, didn't even make a stand that I recall on that human life begins at conception. Right. And they went for something else instead. So that, I think, to me was a big disappointment. But yet it is, we're not really surprised. We're not shocked by that, right? Because we do see that sort of behavior from, the pro-life movement, the pro-life lobby, the pro-life establishment. That's what we see. And, we think that is, that's incongruent with what Christians should be about. Christians should be about standing on the firm foundations of God's word, that we are created in the image of God, and standing on the firm foundation of the Constitution, the U.S. Constitution. And, that's what we ask legislators to do, right? That's what we do when we go to the Capitol in Texas, in Austin. We ask legislators to, stand on the authority of the U.S. Constitution. If we believe that they're humans, as I said earlier, and we believe that abortion is not a right granted by the Constitution, then we should act like it. We should start acting like it. We should stop groveling at the feet of a court which is acting outside of its jurisdiction and going beyond the authority that has been granted to it. And so we should stop the groveling. We should simply obey the Constitution. You can't obey the Supreme Court and obey the Constitution at the same time when it comes to this issue. You have to, and we have picked, historically, that we are going to obey the Supreme Court as opposed to obeying the Constitution. And that's our main call. That's why we continue to say over and over again, ignore Roe. That's one of our main taglines, is ignore Roe. We're not saying that we should ignore the Constitution, or rather ignore the Supreme Court, or that they are always to be ignored. No, they are, as you've pointed out many times, they are a constitutional creation, but there are limits put upon them. And so that's why what we mean when we say ignore Roe is like, what we're actually saying is just follow the Constitution. Exactly. So it's really a pleasure to be here, and thank you guys for sticking with us, and definitely sign the petition to put your name on as a supporter of this brief. If you haven't read it, go read it. And help us out if you can with your donations. They enable us to be here, to do this sort of thing today, and to bring this sort of legal analysis to you. So we really appreciate the support. A lot of us are, most of us are doing volunteer work on this sort of stuff, and so we really do require your support. Without your support, we can't do this. We can't come out here and do this. So thank you guys so much for tuning in, and I'll turn it back over to you, Brad.
Thank you, Wes. Very grateful for you. I'm going to go in a moment to another one of my colleagues with Foundation to Abolish Abortion and Abolish Abortion Texas. But first, I want to just read you a quick statement from our brief, because one of the issues that we have is that people treat the Supreme Court as if we owe it unconditional submission. In fact, we've reprinted our brief in a little booklet. Right here, unconditional submission, Roe, the court, the Constitution, and God, the message of abolition presented to the Supreme Court of the United States. And that's, if you go look at the brief, that's what you'll see on our website at faa.life/Dobbs-brief, I believe. So you can see that there. And that is because there's only one to whom we owe unconditional submission, and that's God. If we give that kind of submission to anybody else, we're really treating them as God. And that's why the way that I describe how many of us have treated the United States Supreme Court, even how I have treated them many times before, is what I would call civil idolatry. We're really putting them in the place of God and bowing down to them instead of bowing to God. I just want to read a part of the brief here. It says, over time, Americans in general have increasingly come to treat the court as having absolute authority, or near to it. Its opinions are our commandments. Its judgments are our last resort. Its decrees are infallible. Its word is final. Its rule is law. We may disagree with the court. We may question it. We may even seek to change it. Yet we do not dispute its authority. We acknowledge it alone as having the ultimate prerogative to determine right and wrong, good and evil, life and death. When the court is just, we follow it. When it errs, we follow it. When we are attacked, it is the refuge to which we run, the name which we invoke. It offers salvation to those who put their trust in it. We lay our problems at its feet to resolve. Though it may be slow to save, yet our faith in it only deepens. Its members are as our messiahs. The one who appoints them is as our high priest. Its only standard is itself. Right? That's basically when you argue stare decisis, as we heard argued several times today, arguing that their standard is their own precedent instead of the Constitution or God's law. We study its words as sacred script. We conform our actions and statutes to its proclamations. It is supreme over all laws. It is sovereign over all authorities. All must bow before it. That's how we've treated it. Regarding Roe, instead of refusing to comply with an evil judicial ruling, we have willingly submitted ourselves to it for the last 48 years. We have chosen not to deny the court's authority to authorize the slaughter of the innocents, but to validate it. We write our laws being ever so careful to ultimately comply with the court's opinions. We parse its decisions, looking for loopholes and gaps that we can exploit, like moving 20-week to 15-week bans. We work so hard to find vulnerabilities with its rulings while being ever so careful not to challenge its authority, no matter how far outside its legitimate scope it goes. When the often compromised laws we write are challenged, we return to the court asking for permission to continue regulating abortion as health care instead of abolishing it as murder. We say, may it please the court, and we are grateful when it gives us crumbs. Yet, of those who hate the court's decision in Roe, almost none call it illegitimate, which is what we call it as abolitionists. To the contrary, our response, the response of many Americans, even most Christians, and even the pro-life community, is our response is merely that we must change the membership of the court. We must get new justices appointed. To this end, we give our votes to anyone who tickles our ears with promises of court appointees who will follow the Constitution and reverse the court's bad jurisprudence. Our litmus test for presidential candidates is that they tell us what we want to hear. We will nominate pro-life justices, then things will change. We believe them. We repeatedly put our faith in them no matter how consistently they miscarry it. The court in Roe has said that evil must be allowed to run rampant in our land, contrary to God's commands to magistrates to restrain it. But if God commands one thing and the court commands another, whom do we obey? If Americans are unwilling to say no to the court, what have we made it? If Americans are unwilling to say no to evil, what does that make us? There's a lot of other stuff in the brief that I think you'll find very encouraging, very helpful. I'm grateful for the tremendous support that we've had from the brief, the 21 total organizations that have signed on to it, the 20 state legislators that signed on to it, and the numerous other Americans that have signed the petition, which you can do at abolishAbortionTX.org/sign the brief. The link is in the description right here on YouTube or on Facebook. All right, now I'm going to bring in another one of my colleagues, also on the board of the Foundation to Abolish Abortion, and also with Abolish Abortion Texas. J.R. Haas is our vice president at Abolish Abortion Texas. Thank you, J.R., for being out here. What do you think about the oral arguments that we heard today and about why we're here? Maybe some comments about our brief.
Thanks, Bradley. Well, I got to hear a little bit of what was going on. I'll comment on that, but also share a little perspective on some things we saw on the ground here as well. As you were just mentioning, this idol of legal precedents that they commented on and spoke to a couple times, as they were talking back and forth, it was almost as though with that logic, you could never admit you were wrong. So I mean, it's like, if you've said it, it's true. And rather you go back and re-examine the argument based on new evidence and find yourself to be in error, you would never admit that if you're the Supreme Court, because, well, legal precedence is the law of the land in, as it relates to the court. Some of the arguments, and you've probably mentioned some of this, but they were discussing, what was it called? Burden of proof, or no. Was it burden on the woman? I can't remember the name of the
undue burden.
Undue burden. That's the word I'm looking for. They were discussing how troublesome it is to kind of legislate that, and how problematic it is to really define what is undue burden. And as they were grasping for ways to explain undue burden, why that's a bad standard, I was just considering, like, what about the standard of, like, thou shalt not murder? Is that a good clear cut burden? I think they could relieve themselves by really trusting in a higher principle, one that is in our Constitution, that all men are created equal and deserving of equal protection under the law. And it's as though there's just a blind spot in the court, whether it's one that they choose to put there or one that's just truly something they don't see. But ultimately, they're not applying the higher principles, and rather than speak to the issue at hand, the injustice of murdering unborn children, they're speaking to the life of the mother and what kind of burden it puts on her. Now I'll kind of transfer back to kind of some of the observations I saw outside. There's all kinds of various voices and organizations, and whether it was just the ultimate pro-life PA system over on the right, or the pro-choicers over on the left, or the fire and brimstone Christians in front of the pro-choicers, or the pro-choice atheists. I saw several things being communicated, and one of the things I learned is the chants of pro-life organizers and the pro-life atheists were had a stark contrast. At times you'd hear chants coming that said, take your forceps off our fetus. And I was just thinking out loud. I mean, just thinking to myself, I commented to another brother. I was like, well, that's not even accurate. Like pro-life women and men, like pro-life women, we don't have a problem of injustice of forceps being given, used on women who don't want abortions. So we're missing the mark there, even in our chants. I actually found the pro-life atheists to be more on point. I don't remember the chant exactly, but it was something to the effect that pro-choice, that's a lie. Preborn children didn't get to choose life, or something like that. So I was very just reflecting on the chants. I was just seeing where some of the arguments are, some of the conversations from people speaking. You heard this thought came to mind: the soft bigotry of low expectations, and what made me think of that was in some of the discussions to rally, the pro-life groups. Many were talking about how wonderful women are and their stories and all, and I just thought, like what is that really the mark? Like, do we celebrate? You know what? This mother woke up this morning and she fed her children. This father, he went to his story, man. He went to work and he provided for his family. Like, if the bar is that low, I'm not saying those aren't good things. Those are excellent things. Those are good things. But that's not the issue at hand here. Like, there are millions and millions of children being slain in the womb. And yet we're talking about how wonderful these ladies' stories are that have chosen life. Man, praise God they chose life for their children. But again, we're moving the focus away from the injustice at hand, which is, sin in the hearts of women and fathers and communities, where we actually have allowed for the last almost 50 years women to legally and sometimes subsidized through our tax dollars to terminate the life of their children. And yet we're still, the arguments are over here on the edges, or I would call it the scraps off the floor, instead of addressing it head on. Again, another thing of reflection that I couldn't help but notice is first of all, the question is, when does life begin? And there was an argument that I heard where the defendant was arguing that we have more science, we have more information now, and one of the justices was just mentioning that, well, we haven't had that much more information, and everybody still just thinks what they think, and they're still just as vocal, and they scream loud on both sides, and everybody's still they still have their own opinions, and ultimately it's not it's not the change in evidence that's going to change the nation. It's going to be, ultimately a fear of God. Where do we derive justice from ultimately, right? Where is value placed? How do we distinguish human life from animal life? Scientifically, we wouldn't debate whether or not a bald eagle, like when does a bald eagle become, protected? Like, is it once it has an egg and then that egg opens up and it's a brand new bald eagle, like an infant bald eagle? No, if you went and crushed bald eagle eggs in our nation, the science is pretty clear that you just terminated the life of a bald eagle. And unfortunately today, this cognitive dissonance where on one hand, we're arguing about undue burden on mothers, and yet we're not even addressing the shed blood of preborn children. And at the very same time, we do have protections under the law for animals. It's amazing that we can't piece this together. I'm grateful that this argument is being had today. I am interested to see what comes of it, but I'm still very skeptical in just the terms of the argument. And I liken it to an analogy of showing up to a gunfight with a knife. And if we're not going to press in and lean into the idea that life begins at conception, that we're made in the image of God, that every life has value, regardless of the circumstances, regardless of the burden on the mom and dad. Like, there's not enough burden that justifies the murder of your own child, right? And when we abandon this idea that the child has value, and that based on various circumstances, the mother then is afforded this opportunity to really be a special class of person who gets to deem one life valuable and then to deem another life unvaluable. That is a precarious situation. And, as much as, the murder is on the hands of the mother and father, the murder of these children is on the greater community, right? It's on us as a civilization, as a culture, as states, as a country. And, we have to continue to rise up and press these ideas and call this nation to repent, to call this court to repent. As Wesley mentioned, I'm sure Bradley mentioned as well, we are for order. We are for authority, God-given authority that is established, and the credibility of that authority comes from God. And in so much as this country has been formed under this Constitution, we believe these powers are credible. But when a branch of that government operates outside of its jurisdiction, and then, as I mentioned earlier, and I won't get the Latin phrase right, but the stare decisis, I'm looking for a head nod from Bradley's. Stare decisis. Okay, so legal precedents. I'm going to use the layman's terms. So, but as they've gone and made decisions that scholars could argue on both sides, but with first principles, when we look at how not only have we seen that we do know when life begins, even though they reject to acknowledge that life begins at conception. Science is clear that anywhere else you look throughout the animal kingdom and for humans that we know when life begins. If we found a zygote on Mars, we wouldn't say, you know what, I can't wait for another 15 weeks when this becomes life. It's going to be excellent. It's like in fact, if we found bacteria on Mars, the headlines would say, we found life on Mars. It's almost as though if we found a 14-week-old on Mars, we would just all like look at each other and then look to the mom and be like, is this a life, or do we need to wait another week? I heard another gentleman speaking over on the pro-life side, just really chanting like, at 15 weeks, these children are babies and they have life and they deserve protection. And to me, it's like, do we not see? Like, what does this mean? Like what about 14 weeks? Like, what about 13, 12? Like, where did 15 weeks? Who are we to say that life has value at 15 weeks or at a heartbeat? And so, anyways, I just appeal to, all Christians, all God-fearing men and women who love life, that love God, that they would see that we're leaving our best weapon, our best arguments back home, and we're running into the halls of the Supreme Court that's abusing its power. And as it's made bad decisions, it's actually admitting that, hey, we're just going to go with the bad decisions we've already made. Whether we're never going to actually reevaluate whether they were good or bad decisions. We're just going to stay committed to bad decisions. That's unfortunate, but ultimately we have an opportunity in this country to influence our legislative process at our local, our state, and at our federal level. And so, I hope today that you're encouraged by the fact that the conversation continues, you supporting the brief and putting your name on it, sharing it with your neighbor. That's ultimately spreading the message of a different narrative, hopefully a narrative that is more in keeping with the principles that we find not only in God's word, but throughout general revelation, that that life does begin at conception, and that all men are created equal and deserve equal protection under the law. So, Bradley, I think we're having a low power moment. I don't know if we're still streaming or not.
I think we are. I don't know what this is.
Pardon us, guys. I think we are still streaming, but we got a pop-up. Very good. Well, it appears we're still going, maybe.
Checking on this. Just checking. See what's going on. There you go. All right. I'm not sure if we're still live here. I'm going to check in and make sure that we are. Oh, apparently we're on audio only. Hold on 1 second. We will be right back in just one moment. So stand by. All right. I think we are back here. Okay, we moved to a different spot. I think you can tell that. And now we're reporting here. So hopefully we have a good signal here. That one had another little hiccup, but we went a long time. Praise God with a really good signal. So we're very, very grateful for that. Let me talk a little bit more about the brief. One thing I want to let you know is that you can get a copy of this brief. You can get a copy of it. Not only can you go look at a copy of it and read it online by going to faa.life or going to abolishAbortionTX.org/sign the brief. And then at the bottom of that page, there's a link to the brief where you can go read it. Now you'll see me using two of these. So this is what the brief actually looks like filed with the Supreme Court. It's green, which indicates that we are an amicus, a friend of the court, amicus curiae. So that's why it's green. So this is what it actually looks like when it's in the hands of the Supreme Court justices and their clerks. But we decided to print it and make it into a little booklet. That's what we did here. Has a little bit of an introduction, but then the rest of it is the same brief that we filed with the court. So if you want to go look at that, you can do that. abolishAbortionTX.org/sign the brief, link in the description. But you may want to get your hands on an actual copy of it for yourself. You may want to have a copy for yourself. And if that's the case, you can actually go to our website and purchase a copy at cost, $4 to get one of these, so you can have it in your hands, and you can even buy a lot of them and hand them to people if you want to. So that way you can get out the message of abolition written to the Supreme Court, the message of abolition presented to the Supreme Court of the United States. That's what we have right here. You can go to our website, abolishAbortionTX.org, and get that. They're telling me that the link to that has been posted in the comments on YouTube and Facebook, so you can get that there if you want to order some of those at cost, so you can have those and hand those out to people. So just wanted to let you know about that. So with this brief has been supported by numerous other organizations. I just want to take this time right now just to list those organizations that you'll see right here on the front of the brief. And the Supreme Court, when they read this, they'll see these right here. But I'm going to read these to you just so you know all the organizations that signed on to support this brief, supporting the message of abolition to the U.S. Supreme Court. And that is, of course, our organization, the Foundation to Abolish Abortion and Abolish Abortion Texas. Also, Action for Life, Free the States, Rescue Those, Operation Save America, End Abortion Now, Colorado Right to Life, American Right to Life, Abolish Abortion Arkansas, Abolish Abortion Idaho, Alaska Right to Life, Abolish Abortion Pennsylvania, Southern Baptist for Abolishing Abortion, West Texas for Life, Liberty Rising Institute, South Carolina Right to Life, Abolish Abortion North Carolina, Love Life, Voice for the Voiceless, Scott Horde Ministries, and as I said, numerous other Americans. So if you follow any of those organizations, you keep up with them, you like those organizations, I just want you to know they've signed on to this brief. They've put their names on this brief. And so please add your name as one of those numerous other Americans who support the brief. Go put your name on the brief right here. Let me just show you right here in the brief. One of our very first footnotes, very first points in the brief. Hold on, where are we at? Hold on, here we are. All right, yes. In the brief, we point out that the names of numerous other Americans for abolishing abortion may be viewed at faa.life/Americans. And if you go to there now, it says that those names are going to be posted after these oral arguments today. So get your name on there, so that way when the court and their clerks go and go follow that link to see the names of numerous other Americans who support abolishing abortion, they'll see your name on there. And they'll see the names, hopefully, we want the number to be as big as possible. So please get your name on there so that your name can also be there. All right, I just mentioned numerous other organizations who are supporting the brief, who signed on to this brief. And I have a pleasure right now to bring on one of our good friends. Many of you know him, many of you don't. And so I'd like to introduce him, Pastor Jeff Durbin from Arizona. So how are you?
I'm doing wonderful, brother. It's a blessing to be here today with you.
Well, thank you very much for being.
It's a big deal for you, right? I mean, you have that brief that went in during this case, and so you're kind of the superstar of the day.
Well, by the grace of God, I mean,
I know.
You know, we're all here by the grace of God, and I'm grateful for the 20 organizations who supported the brief, the 20 legislators who signed on to it, and I just want to ask you to talk a little bit about why you're here today, and why you support this brief, and just what your organization, End Abortion Now, and your church has all been involved in.
Yeah, so End Abortion Now is a ministry of apologia church. The focus is raising up churches to go save lives with the abortion mill, to create media content that would really saturate the culture in the world with the gospel in conflict with abortion, a specific Christian message, no compromise, under the authority of Christ, and to work together with legislators in the states to get bills of equal protection. You've done that all with us across the country. And we're here today because of really the amicus brief that you filed, which we think is a very, very important thing. It's a very big deal. And I think in many respects, it's unprecedented in this fight to have a brief go in like this to argue a legal case that focuses first and foremost on the authority of Scripture, the authority of Christ, to have a consistent Christian response to the court, really calling the court to repentance, to return from their fallacious, erroneous, and evil opinion, and to point him back to the authority of Jesus Christ, to argue for, of course, the overturning of Roe versus Wade as a court opinion, and to uphold the principle of this nation, that's to preserve life, liberty for all human beings. And so this is a very big day. I think I give all glory to God for everything he's doing through us. Obviously, this is his work. Ultimately, it's not ours. We're just spectators in some sense. But this is a very big day, I think, for all of us to be able to see these, call them mustard seeds, that are going to grow into large trees. One of the things that I'd love for people to hear about a moment like this is that you can't see it obviously from here, but on the bottom there, you had really the pro-choicers were taking the left side, and the pro-lifers were taking the right side. And so you couldn't really hear most of what they were saying because they were going through loudspeakers on both sides right next to each other. But what's interesting is that you have people here that are pro-abortion. They're on the left side over there. They have, all the shirts that say, I had an abortion. You have all the shirts that say down with the patriarchy and abortion is healthcare. I mean, they're here. You would hope to fight, right? In a good way, in a respectful way. Let's get into it with each other. And so I came here looking forward to some conversations. And what I learned was more and more and more, the pro-aborts are unwilling to actually engage, because their message, their foundation is just all bluff and bluster. It's just all just noise. It cannot be defended. They cannot survive under any cross-examination. I got about 30 seconds with a pro-choicer who was just, dolled up with everything pro-choice all over her face mask, her shirt, everything, and her sign. I got about 30 seconds into a conversation, and I gave her just a mild challenge, and she just didn't even attempt in response and just walked away. They're not even willing to engage, and the reason is because they can't engage. They can't survive under cross-examination with their position. It is simply a moral issue. It's not an issue of reason. It's not an issue of logic. It's an issue of morality. This is an issue of sin ultimately, and it's a moral issue. It's a philosophical issue, and it's a question of what ought we to do, not reasoning to a position in terms of what's reasonable, what makes sense, what's consistent. Their issue is just a moral issue. They believe that they have the right to murder their children, and that's what they're here for. And so that's what's taking place. I think a lot of that has so much to do with the consistent Christian message that's been preached, of course, since Roe, but really specifically over the last decade, really challenging them at their foundations in many ways. Hearing the word here coming from pro-lifers, even calling it murder and things like that, that is something even many at the top are very hesitant to do, but you're hearing it more and more and more. And so that seed is growing into a large tree, and it's a gift to be able to watch.
That's great. I heard when I was listening to the court, one of the justices said, well, are there any secular philosophers? This is one of the Republican appointed justices, right? Are there any secular philosophers who talk about when life begins? And even at one point, one of the Democrat appointed justices said, the issue of protecting, you say protecting life. Well, that's a philosophical issue. That's a religious issue. And I thought, well, I mean, isn't it also the same on the other side, right? A mother's so-called right to an abortion, isn't that also a philosophical issue? Can you talk to us a little bit about why any idea of, going to secular arguments and things like that has been a big problem for the pro-life movement for the last 48 years, and why it's really been one of our Achilles heels?
Yeah, that's what I meant when I talked about philosophical. It's an ethical question. This is an ethical question. It's not merely an ontological question. I don't want that to throw anybody. We're not talking about just simply what is the case, right? Because we can demonstrate without question that what is the case in the womb is human. That's what is the case. They don't care what is the case, right? They care what ought to be the case. They ought to be able to murder their child. They ought to be. We're saying you ought to not be able to murder your child. So it is a question of philosophy, and it is fallacious to suggest that the Christians are the ones with philosophical presuppositions and pre-commitments, and the secularists just don't have them. And we just want to know what is the case. Because, well, okay, well, let's get there. Let's do it. What is the case? What is the case is that it's human in the womb from conception, from the moment of conception. And you're going to find about 5 seconds later that it doesn't matter what is the case. For them, it's philosophical. It is based upon their commitments to their worldview. They believe that they ought to be able to murder their child. And so this isn't a question of Christians are the ones carrying presuppositions and the unbelievers, they don't have any. They're just approaching it with neutrality. Neutrality is a myth. It's a myth. Biblically, it's not possible. Jesus says, if you're not with me, you're against me. And philosophically speaking, neutrality is just a myth because everybody has a basic perspective of the world, of reality, of how to reason, what value reason has, and how they should live their lives. Everybody has that. Even if it's not really well thought out, it might even just be something that they've caught, right? They caught it from Lady Gaga, or it's through her lyrics. I've developed my ethical system, sort of a thing. But everybody has a basic worldview and pre-commitments, and so we need to challenge those pre-commitments and really go after the heart of the argument. It's an ethical question. What's in the womb is human from conception. It's one of the things that I think that needs to be. You need to have a target right on that with Roe. When Roe specifically talks about what's in the womb as potential human life, that can easily be refuted now, right? From both sides. I mean, the pro-aborts will say, no, we know it's human life, but we think you ought to be able to kill it. And you're getting down to the ethical question. It's a question of morality, not of what is the case, but how shall we live? So, and of course, the ethical dilemma of the moment is we're living in a nation that is so secular, so humanist, so abandoned the foundations that gave us this nation, and even a court like this. They're in an ethical dilemma because they believe they should be able to do sexually whatever they please. And then whatever the result of that sexual experience is, if it's a child, I ought to be able to kill it. It's an ethical question. It's not an ontological question. It's an ethical one.
Well, I think we're about to have to move in just a moment, but I want to talk about one more thing before we do. And that is that, we see in Scripture that God says, if the people of the land do close their eyes to those who are sacrificing their children, that God will not only bring judgment upon the one who's committing the child sacrifice, but also upon the people of the land. And we're seeing that in our country. And we also see how God says that if my people who are called by my name will humble themselves and pray and turn from their wicked ways, seek my face, then I will heal their land. A big problem is that for the last 48 years that we haven't seen the church doing a whole lot. The church being led by their pastors, getting out and doing stuff. And I'm very encouraged that your church is one of those who is doing something. And can you tell us a little bit about what y'all are doing and about your ministry to help inspire other churches through End Abortion Now?
So we were never the experts and never wanted to be the experts in this. It was just really a matter of us repenting of sin and our apathy towards this. It was us knowing that we have a responsibility to try to save these children and to bring the gospel there to the abortion mills. And so for us, it really just started. Our church came out of a drug rehab, a bunch of baby believers who became very passionate about saving these lives at the abortion mill. We went to the mill with the gospel. We offered to help start saving children. We had a radio program where we were basically doing our show and announced, hey, by the way, we saved a child this weekend. And so that started other churches hearing it, other believers hearing it and saying, hey, how do you do that? And we would just basically say, well, we don't really know. We just go, we preach the gospel, we offer to help, and we love them. And we offer to adopt their children. So that grew and grew and grew to the point where we realized we can help these churches. We can, put together things for them and give them training and actually equip them so they can do what we're doing and save lives at the abortion mill. But we knew it was never enough. From the very beginning of End Abortion Now, the goal was never to simply raise up ministries to save lives, because, that's at the end of the river. It's like it in some sense, it is like trying to drain a river by using buckets. At some point you got to work up here to stop where that water's coming from. And that's this place. And that's the legislature, where it's allowing for this injustice. And so from the very beginning, it was about raising up the churches, making sure that everyone knows the message of the gospel related to the issue of abortion, take down abortion arguments, and to work towards speaking to legislators to actually criminalize abortion. That's what we're doing. A three-pronged approach.
Awesome. Well, thank you all for your testimony there and your witness there. Where can people find out more information about End Abortion Now? Maybe get their church plugged in.
EndAbortionNow.com. Just go to the site. You literally just get signed up. We have someone call you to encourage you, talk to you, make sure you're connected to your elders and that you have a church body that can support you in this. This is a very difficult ministry. It is not easy. It's very hard. And we believe it needs to take place in the local church context. And once your church gets signed up, we give you free training. We give you free resources. We stand available with you to talk to you, to equip you, to help you. We also connect you to something we created that actually connects you on a daily basis to all of the churches that have signed up or gotten training from EAN. They're their own ministry. They're their own thing. They're not our ministries. They're local churches doing their own thing. We're here as a resource for them, but we provide a way for all these churches to also talk to each other, and for us to be able to talk to them and say, hey, we have this thing going on in South Carolina or this thing in Pennsylvania. And so, yeah, everything is free. We ask nothing from the churches, and we help them as long as they need us to. Yeah.
Thank you very much, Jeff. Absolutely. And thanks for End Abortion Now signing on to the brief. If your church is not already plugged in there, I encourage you to go to endabortionnow.com and get plugged in right away. It's a wonderful ministry. So thank you, Jeff.
Thank you for all
Thank you. So End Abortion Now is one of the organizations that has signed on to the brief. If you have not yet signed on to the brief, go to abolishabortiontx.org and add your name along with others like End Abortion Now, Action for Life, other organizations who signed on to the brief, so that way you can get your name on there as well. All right, I think we are having to move here, so we're going to pick right back up here in just a few seconds. So please just hold on here, and we will be right back with you. I'm going to go, we're going to go to our screen here. Thanks. All right, I am back here. Sorry, we just had to move, so we were in someone else's shot, or about to be, so we needed to move over a little bit. So I want to continue with what we did just a moment ago, because there's some other organizations that have signed on to the brief. Like I said, 21 total organizations signed on to the brief, 20 legislators. Like I said, numerous other Americans like yourself. Please go sign on to the brief at abolishAbortionTX.org/sign the brief. But right now, I want to invite a couple of my brothers, if y'all would come on here, get in the shot here. This is Zach Lautenschlager and Dennis Arfate, and their organization, Action for Life, has also signed on to the brief, and in fact was our lead sponsor of the brief. And so we're super grateful for them and the work that they've been doing across the country in lots of states, talking to legislators, helping getting more bills, and I'm helping draft bills, but they're the ones talking to legislators and helping to get those bills filed. So I want to introduce you to them, to Zach and to Dennis, and give them an opportunity to tell us about Action for Life and the work that they're doing and why you signed on to the brief. So Dennis, you want to get started?
Sure. Yeah. So for me, this whole fight is personal. My wife's story, her mom choosing life, 30 something years ago. I won't give her age, but and what she has done to bring me to the Lord and all these other things that God used in her story. When we got involved in 2014 with Jeff and End Abortion Now, it was a passion for us, and we wanted to see it ended. That's how Action for Life got started. Was we realized that you can go out to the mill every day and share the gospel and save babies, but they're going to keep doing it. There has to be some kind of law. There's got to be legislation that goes in. So that's how Action for Life got started. We've been going around, like you said, statewide, getting legislation put in. But the biggest thing about the brief was we wanted to go, we would say, we defy the Supreme Court ruling. It's not a law. It's not law. We have to understand that. But we want to point them back into the right direction, that they have been unconstitutional in their ruling, that murdering babies is never a good thing. It should not be allowed. They were wrong in 73. They were wrong in the Casey case. Now let's get it right. Right your wrong. So that's why we supported the brief. The work that you did on it was amazing. And it came from a biblical standard. You can fight against this. Like we saw atheists out here for life, which it really doesn't make sense from their worldview. But when you can point the court back to the word of God and what God's word says on this, that's your standing, and that's what we should stand on.
Zach is also vice president at Action for Life and has been working in the political community on this issue and many others that I hold near and dear to my heart for a long time. Do you want to tell us a little bit more about Action for Life and some things that y'all are doing in states around the country right now, and how people can help with that?
Right. Well, thank you, Brad. It's a pleasure to work with you. We really appreciate working together on bill drafting and on many other grand conspiracies that are very important. We're privileged to work with the Foundation to Abolish Abortion, who drafts most of our bills, and we're excited about right now there's legislation in the hopper in Pennsylvania that Bradley drafted, but that we have got to the point of the introduction. We have sponsors, we have, I think, co-sponsors working with their state bill drafting to finalize that. So that's coming along. We'll be actually in Louisiana tomorrow. We've got a sponsor who's committed there. And so there's two primary initiatives with a third possible. First and foremost is the bill to abolish abortion. It absolutely does recognize that abortion is murder and needs to be treated as such with equal protection and equal justice for especially the parties at risk, the unborn children. This is just straightforward recognizing that pre-Roe law in most states was at least partially correct and needs to be restored. It also is what's necessary even for those who are hoping that the Supreme Court does overturn Roe eventually based on the arguments, part of which we heard today. But even for those who are placing hope there, and we certainly join in petitioning the court to do the right thing and to right the wrong. They are 1/3 of the branch of our federal government constitutionally established, and they need to return to their authority. If they do, it's still going to be necessary, as I'm sure you've pointed out, that the states actually end abortion within those states. And in fact, unfortunately, many states have repealed the laws outlawing abortion. So this bill is very necessary in many states. Our second major initiative is focusing on defying Roe. Now, this is going to become necessary if the court doesn't do the right thing in a few months. It's very apparent now, after all the blood, sweat, and tears and political capital that has been expended to put supposedly pro-life justices on the court. I will be very surprised if we actually overturn Roe. I hope it does happen. We pray that they do. But unfortunately, what we see coming from Gorsuch, Kavanaugh, and even Amy Coney Barrett, they are not ruling consistently with the positions that they have espoused in past. And I actually have personal experience, like with Gorsuch, when he was on the court, on the appellate court, he heard cases that we had before him, and actually did a much better job in some cases there. So if that is the case, the states need to stand up and recognize that Roe-based law is not law. They need to institute penalties for state actors, that would be state law enforcement, legislators, et cetera, who try to enforce Roe-based law. And this is an important initiative. The third thing that we're focused on is defunding all abortion providers. This is something that is completely consistent with justice, is 100% in line with what we understand from God's word as to what the role of government should be. And we can say just categorically, whether you want to have a discussion about the right to life or anything else, constitutionally, government should not be paying for abortion, period. Then we can talk about the fact that they are paying for murder, which is a whole other issue, whole other discussion. On any level you look at it, you should not have states accepting money from the federal government and turning around and doling that out to anyone who would commit abortion. So there are efforts to restrict funds from going to abortion, but it can still go to an abortion provider, quote unquote, which is ridiculous. Unfortunately, abortion providers know how to balance their bank accounts. So there is absolutely no good argument for that kind of funding. So these are the three major initiatives that we see. We're working in 25 states with legislation active in about 11. And we've got 4 or 5 more on deck as we enter legislative season. So it's very exciting.
Awesome. Well, we're very grateful for our brothers, Dennis and Zach, and the work that y'all are doing with Action for Life. And again, especially with this brief. I was able to do the writing on the brief, but a lot of other organizations came in and helped support financially to make that financially viable to do that, but none more than Action for Life. So we're very grateful for y'all being the lead sponsor of the brief and for the work that you're doing.
Proud to work with you, Brad.
Yeah, absolutely.
Thank you all. Thanks very much. All right. Well, we are getting near the end of our time here for our stream. And, you know, I'm not really feeling all that tired. I mean, I'm having fun. Having fun doing this. Now, that said, you know, it may be enjoyable to be here and be in person and talk about this and stand in front of the Supreme Court, but we're talking about something very, very serious. And that is the shedding of innocent blood, which is made in the image of God. And that's something we need to not be afraid to say, that children from the moment of fertilization are made in the image of God. And because of that, more than any constitution, more than any law, they are deserving of equal protection. In fact, that's the fundamental reason God created government, was to provide equal protection to human beings, to protect innocent life, to provide justice. God has commands to magistrates in Scripture. It says, do justice, provide justice, execute justice. And not just general commands, he has specific commands to do that for the fatherless. Who, from a legal perspective, is more fatherless than children in the womb, whose fathers have zero say in whether that child's life is destroyed or not? Those are the most fatherless in our country today. And our civil government is instituted by God, not to bear the sword in vain, as Romans 13 says, but to execute justice as his ministers of justice upon the evildoers who would commit crime, the greatest of which is the shedding of innocent blood. So that's why I'm passionate about this issue, because God's passionate about it. I love life because God loves life. I hate murder. I hate abortion because he hates it. That's why we do what we do at the Foundation to Abolish Abortion and Abolish Abortion Texas. If you agree with that, if you support that, then I ask you to go to our go to the brief and show your support to the U.S. Supreme Court that you support abolishing abortion. That brief, you can sign on to it at abolishabortiontx.org. The link is in the description right here. You can sign on to that. You know what? It's not just it's fundamentally our desire to please God is why we do what we do, but it's also something very personal. We're parents, we're fathers. That's why we do what we do is the Foundation to Abolish Abortion and Abolish Abortion Texas. By the grace of God, He has given my wife and I 10 children. We're expecting number 10 right now, and look forward to getting back to them tomorrow. But we're very, very grateful for them. We love life from the moment of conception. But we actually have more than 10 children. We have 4 children that we've lost to miscarriage. And every one of those children we've given a name. We've given them names because they're just as valuable. Their lives are just as valuable as every one of our born children. They are equally made in the image of God, and they are equally deserving of legal protection as all of our born children are, as my life is, as your life is. Right? Everyone's life is worthy of equal protection, not because I'm somehow worthy in my own right, but because we're made in the image of God, and He gives us that pricelessness, right? Because He gives us His divine image. We're made in His image, so we're priceless because of Him. So we do what we do, seeking to follow the golden rule, right? How do we want other people to be treated? Well, then that's how do we want to be treated? That's how we should treat other people. Do you want equal protection for you and for your life and for your born children? Well, that's what we should be providing as a society to children not yet born. That's what we should be providing. No one should have a license to kill them. Unfortunately, many of the pro-life bills that have been passed for the last 49 years explicitly write into them a license to kill for the mother and for the doctors that she hires. We need to get rid of that. We already have laws on the books that prohibit murder, right? That's what protects my life and your life. Those same laws should be also protecting lives that are still in the womb. So we believe in following the golden rule. We also believe in following the higher law. And of course, the highest law is God's law. And God says, you shall not murder. God says, you shall not murder. He says, you shall provide justice. And the highest law of the land, man's law, is the U.S. Constitution, which says that no state shall deny to any person within its jurisdiction the equal protection of the laws. And we believe in following that. And we believe in doing so, walking by faith, right? Not trying to figure out, the numbers and the pragmatic arguments and risks and benefits. No, it's murder. We should treat it like murder. We should end it. And we should pass bills that do that and treat it like it is. And so that's what we support here at Abolish Abortion Texas, Foundation to Abolish Abortion. If you agree with that, sign the brief. And by signing the brief, not only is your name going to be, can we show that so the Supreme Court can see your support for abolishing abortion, but also we're going to be able to then email you and let you know more about our work and how you can contact your legislators and let them know about abolishing abortion and tell them that you want them to abolish abortion by providing equal protection and to do it now. Now is the time for justice. And we, at the core of everything we do is we want to do it for the glory of God, because that matters more than anything else. That's why anything else matters. That's why life matters, is because of God. And we want to do everything for His glory, as He's called us to do. He's given us so much, and everything we do, we want to do as an act of service to Him, being obedient to Him. We want to sow the seeds, and we trust Him with the results. That's why we use Scripture. That's why we talk about God's Word, because He says it doesn't return void. We want to walk by faith and not by sight, right? We want to walk by faith and not by fear. Right? We want to do things, we want to do God's will, God's ways, and trust Him with the results. If you agree with that, please sign the brief so that you can be not only showing your support, but also get our emails so you can find out more about the work of Abolish Abortion Texas and Foundation to Abolish Abortion and what you can do to help there. So please go sign the brief. That's all I have for now. This is not the end of this. This is just the oral arguments today. over the next several months. The Supreme Court's going to be deliberating. All that's going to be behind closed doors, so we won't really know until they announce their decision, expected in June. It could happen before then. It could even happen in July, but expected in June for them to rule in this case. So until then and after then, we're going to keep working to abolish abortion in every single state in this country, regardless of what the Supreme Court does. So I want to encourage you, again, maybe you've already signed on to the brief. If you have, thank you. Thank you for signing on to it. Thank you for showing your support. I want to encourage you to go to your friends, let them know about it, and send it to them and ask them, tell them about this, send them this video if they want to watch the whole thing, so that they can sign the brief too and show their support, and they can find out more about abolishing abortion and the work of abolition. So please share this, send it to other people, let them know about what's going on, and ask God how he would have you do the work as well. There's people who can write bills. There's people who can go to the Capitol. There's people who can testify. There's some people that they can make phone calls from home and call their legislators. I would encourage you to seek the Lord. What can you be doing as a people of the land, as he calls us, to fight against child sacrifice in our land? So that's what I'd encourage you to do right now. Seek the Lord how you can help. There's other people who give. God's given them resources and that they can give. And of course, if you give to us, or you give to one of these other organizations, or do you give to any of the organizations who've signed on to this brief, we will seek to steward that and to use that for this work to abolish abortion for the glory of God. So if you can give, I encourage you to give. If not, seek the Lord for what you can do to help abolish abortion and to love our neighbor, the second greatest commandment, as God has told us. So it's been a pleasure to be with you. It's been a privilege to be here. Thank you to our many supporters who've made it possible for us to be here. And thank you for watching. Be praying for the Supreme Court. Be praying for them. Be praying for their hearts. God can change their hearts. God can change their minds. He has their hearts in the palm of his hand. So please be praying for them. Please be praying for us and for our work. And if you haven't already, please go sign the brief at abolishAbortionTX.org. We're going to leave a screen up here for the next few minutes, just so you have an opportunity to navigate over there and get your name on that brief. So that's the most important thing we can encourage you to do, that you can do right now. Right now, if you're watching this, just navigate over to the website. It takes 15 seconds to add your name to the brief, maybe 30 seconds. So just encourage you to head over there and do that right now. abolishAbortionTX.org. Thank you so much. Take care and God bless.